Okay, so introduction, I think we covered that. Actually, there's more to their legal introduction we're going to do. Then there's trademark clearance. That's basically how do we make sure when we file something we're not making a mistake and going to get a rejection of a very bad client. If you're going to file something, if you're going to file something and get a rejection, that's fine as long as your client's okay with that and knows what their chances of rejection are. And then they're not in the dark and you can say, see, I told you so. When they're surprised, they're not as happy usually, especially if they start selling a product under that name and you can't get them to trademark. Then trademark registration application process, that's basically how we go through the application, how we file the application. And trademark prosecution after we filed it, dealing with the trademark office after we filed it. And they're pretty good, they're pretty reasonable. With patents, it's a whole different story. Trademarks, they're pretty reasonable. And I should also mention, any attorney can file a trademark application. You should know what you're doing, but any attorney your license is enough to file it. With a patent, you need a special patent attorney. You pass the patent bar with the U.S. Patent and Trademark Office. So that's where I come in. But for trademarks, you can do that yourself. If you don't want to do it yourself, hey, I'm here. Then once you have the registration, we're over on the next page. We're going to talk about oppositions and cancellations. This is basically once someone has a trademark and it's a problem, you can first, it goes to publication before it issues. The public has 30 days to oppose it. And if they do, and in that window, you can and should oppose it if it's going to be a problem for your client. So just briefly, there's trademark watching services and things to let you know when anything close has published. If it's already issued, then you can petition to cancel it, but it's harder to petition to cancel. It has to be fraud or the name has become generic or that type of thing. But in any case, we'll get there when we get there. Trademark maintenance, basically we want to make sure once your trademark is registered that it will, that you're still using it. If not, we want to let other people use it. So that in translation means pay the government a fee. Basically, anything can be cured by paying the government the fee. You miss a deadline, pay a $100 fee. It's okay. They'll let it slide for 2 months. Keep your trademark active, just keep paying government fees. It also means, corollarily, each time that you do this and have to pay a government fee, the lawyer also gets a fee because you bill for your time. So it's not that bad for us. And it does make sense, even though it does cost money, it makes sense because we want to make sure trademarks are in use. And then finally, we're going to do some ethics to help get in that ethics time that we're required for our CLE requirements. And when you give these talks, you get double time, which is really nice. And I like giving them besides. Okay, so let's turn now to page 4. And we're going to start with the attorney's role for clearance to renewals. And this is basically telling you that, I'm not going to read through this because you can read through this on your own time, but basically this is what we cover beginning to end, what I just kind of went over. And then let's go over right to page 5, the introduction. Trademark basics necessary to counsel trademark clients in the selection, searching, filing, registration, and maintenance of their trademarks. I pause here to tell you that my watch band broke, and therefore I didn't bring my watch, so if I'm going too slow or too fast and we're supposed to be at another section, please just tell me. I'm fine with it. And if you have questions, I know this sounds like everyone's got some interest here, but it's still a requirement, and the way I deal with having to do with CLE requirements, I give the CLE talks because that's what I like to do. So feel free to make this interactive. Stop me, ask me questions. We can argue back and forth. We can talk about crazy cases in trademark law. We can make this a little bit more fun than the dry going through the data. So, introduction. What is a trademark? So a trademark is, as the definition is put here, this is actually a paraphrase from the Manual of Trademark Prosecution. Trademark is a word, phrase, symbol, or design, or combination of words, phrases, symbols, or design which identify and distinguish the source of the good or service as one part or the other. Basically, a trademark can be anything which, to quote, what's his name? I can't think of his name. The famous guy who writes his treatises on these things. But it is anything which is a source indicator. Anything which indicates a source of goods. So it can be a jingle. Now you can actually electronically upload a sound to register a trademark. It's not done very often. It can actually be a color in some limited cases, a color that a person recognizes to a certain product. It would be limited registration of that color only for that type of goods. For example, there's like a certain shade of purple that's registered for a washboard that's used in dry cleaners. that they were actually able to register. It can be a logo. It can be a name of a product. If a person here, I have Miss Soda, I'm sure Sierra Miss, they have this trademarked up the wazoo. Sierra Miss, the word mark, would be one registration. Sierra Mark, the stylized design with green and this color scheme and font, that would be a separate trademark application, which means separate government fee. When in doubt, there's an extra government fee. And a service mark is the same thing. Could be any of those things, but it represents a service. Practically speaking, the way you file them, the way you prosecute them, they're the same except for one step, and that one step is proving use. The way you prove use of a trademark, you have to submit a specimen, Sierra Miss Soda, take a picture of the bottle can, submit the picture to the trademark office. The one cool thing about this is you don't ask your client for pictures, you ask your client for a product sample. Why? Because they need a free product sample. Pretty fun. Anyway, I've given my kids all sorts of fun toys and things that way. If they want to send a picture, I tell them to send a picture. But in any case, you just submit a picture to the trademark office, and electronically it's very easy. They email you a JPEG, you upload it, or a PDF. They accept JPEG or PDF. You can still file on paper. The way I learned was filing on paper, which is perhaps better because you have to fill out the entire form and you have to know what you're doing for each thing. Now electronically, you just sort of fill in the data in an online form, and it just makes it very easy to do, and at the same time, clients often do it themselves, and then at the same time, I often get clients who then come to me when they mess it up. So it's a mixed bag. But if you know what you're doing, the system is very easy, and it's very quick to file a trademark now. Like once you do 100, 200 of them, you can prepare a new trademark application very quickly, but it's also, again, very easy to make a mistake very quickly, so you got to make sure you're doing it right. All right, governing law for trademarks is the Lanham Act, which is 15 U.S.C. 1051. If you send a cease and desist letter, please quote the Lanham Act. Please quote where they actually are infringing. I can't tell you how many cease and desist letters I answer that say, this is infringement. They'll say, this is copyright, trademark, trade dress infringement, and list the whole thing. They never state the statute, never state the law. This is Abercrombie and Fitch. This is not small companies that do this. That was one of my favorites to respond to. It was total garbage. But anyway. There's also state trademarks. I generally don't deal with state trademarks. I don't even recommend it because it's nothing. You can register an LLC in a state. That's at least you have rights to that name for that LLC. But a state trademark, I shouldn't say is nothing, but it's trumped by a federal trademark. It's basically you pay a fee to the state, like New Jersey has it, and they list it in their database. It's not very useful. There's what's called common law trademark rights, which is the next thing. Common law trademark rights, the way you claim common law trademark rights, you don't need to, you put the TM next to what you're doing. That TM means there's not a registration. It means you're claiming rights based on as we went to law school, the common law, what they developed in the British system and so forth. Before there was a registration system, which you have to go back to the 1700s for this, but before there was a registration system, that was the only way to claim trademark rights. Now, just like on land use, you can claim ownership of a property by being there or by even having a contract with someone to obtain the rights to it, but that's not the same as recording the deed with the county. Same way, you want to record the deed, you can do it with the state. That gives you the equivalent of common law rights, which gives you very limited damages. That gives you actual damages, actual provable damages, whereas a registration, a federal registration, what we're talking about today is the United States federal registration under the Commerce Clause that enables them to do this. Anything which is interstate commerce, which today interstate commerce is just about everything, but anything which is interstate commerce is registerable on the Federal Register. It's a very easy burden to meet. No one questions it. I've never seen anyone argue, oh, really, you're only selling this in Piscataway, New Jersey. It has no reach in your advertising or website to New York or Pennsylvania. You know, so we do federal registrations, which are the whole country. What's the difference between trademark and other forms of intellectual property? So again, just quick overview. So trademark, service mark, we covered. A patent is a limited duration right. It's not written by a patent attorney, is a limited duration right to exclude others from a new, we'll just call it invention because that's not really our topic here, but something which is new and useful technology would be protected by a patent. A copyright protects works of authorship, anything reduced to tangible form, which is an original work of authorship. Sometimes there's overlap. There's design patents, which aren't mentioned here. Design patents protect the look of a functional object. So you could have, I don't have a good example on my desk, but it's actually possible, for example, this cup with the bubble thing underneath, if you said that was a distinctive use, once you say that that's distinctive and no longer descriptive, granted it would be hard to do in this case, there's better cases out there, you could actually get a trademark on that. Where you see this is, I have a lady that sells handbags in Manhattan, and on her handbag she has different patterns, and we trademark her patterns so people don't copy them. And what they'll say is, you can only do it on the supplemental register, which we'll get to, which isn't full rights, until you either have a ton of commercial sales or you're selling it for 5 years and it's said to become distinctive. Any pattern. Like the wallpaper over here, nobody does it because it's not worth it, but you could trademark that wallpaper if it's in use for more than 5 years. Then it becomes distinctive. It becomes yours. Now, generally, we wouldn't bother doing that. Generally, we do copyrights. We do copyrights as an artistic work. Then for things which have a three-dimensional characteristic that have a functionality, for example, the cup again, you could do a design patent. You could protect it based on the look of the functional object. That cup, assuming it were new and you were the inventor and so forth, and it very well might be, you could do a design patent on that cup. So we're not really going to go into that so much today, but there is overlap between patents, trademarks, and copyrights. All right, let's go on to the legal issues. This is part B. On page, did I skip the page? I'm sorry, I skipped the page. That didn't make sense. Okay, let's go on to C, the strength of trademarks. This is now page 6. So this is a typical debate that I have with clients, that all trademark attorneys have with clients. They want to protect a name. I'll give you an example. What is it? I can't think of what it is. It was something like koshermeat.com, and they want to protect that. And that's really generic. It's just describing what it is. So I tell them, no, you want a name like Meebo. Meebo it's an instant messaging program with a made-up name. Now, they don't want that name because you've got to spend a lot of money telling people what a Meebo is. But on the other hand, they want the name that's totally descriptive. You can't get that trademark. And on top of that, if you have a trademark which is so descriptive to what it is, it's going to be hard to protect. It's going to be very hard to stop other users from calling their products koshermeat.com or some confusingly similar variation. You send cease and desist letters up the wazoo, and they're going to, if it's me, they're going to respond and laugh at you. Whereas if you have a totally arbitrary name, it's very protectable. Nobody's copying your name, but from a marketing perspective, they tend not to be very good names. So therein lies the tension between the legal issues and the marketing issues. So you need to find something in the middle, and usually clients want more on the descriptive side. If it's totally descriptive, it can only get on the supplemental register. You're getting basically the equivalent to common law rights that I described before. So you need to make it at least the minimum to get on the primary register without having used it for 5 years and showing distinctiveness is suggestive. You want a name which is suggestive. So unfortunately, I'm drawing a blank right now. Why don't we just flip it around? Why don't I make it look like I meant to do this? Someone to throw out a suggestive name, suggestive trademark. All right, we'll find one later in here. Here we are, the very next page, page 7. So there's examples. A generic name is something like aspirin or escalator. Why? Because that's what you call the products. I can't protect an escalator for an escalator. I can't protect aspirin for an aspirin. Descriptive. IBM is descriptive. I disagree with that one. I don't know why the author of this put that as descriptive. I don't think that's descriptive. IBM does not describe what it is. Perhaps International Business Machines, the full name, describe what they're doing. They're international and they sell business machines. But IBM itself, I would not call descriptive. Steak and ale is describing what they serve. They serve steak and ale, but again, here, it depends what you're registering it for. Personally, I think these are lousy examples because steak and ale for restaurant services isn't necessarily descriptive. You don't know I'm doing restaurant services. And an even crazier example, suppose I'm registering steak and ale for selling light bulbs. It's not descriptive at all. It's totally arbitrary. Totally, you wouldn't connect one to the other. You'd have no problem registering that. Your client, however, would. Your client would not register steak and ale for light bulb sales. So therein lies that problem. Suggestive is copper tone and Tropicana. And these, I would say, are more arbitrary than suggestive, but copper tone, because the idea is suntan lotion that gives you a copper tone. So that's a bit of a stretch there. Tropicana, I think, is arbitrary. Personally, I wouldn't call it suggestive because it doesn't suggest that you're selling orange juice. It suggests that you're something from the tropics. I don't know, it's orange juice. Arbitrary and fanciful, here I agree. Xerox, Kodak, and Apple. But interestingly, Xerox and Kodak, in fact, are strange examples, but as arbitrary, because what happened with these, Xerox especially, and Kodak to a lesser extent, is people started calling photocopying Xeroxing. That's a generic term. So you can actually lose the strength of your mark because people start using it generically. Another really good example is American Express had a trademark for Gold Card. They actually lost that trademark for Gold Card because they didn't protect it. They didn't stop other credit card companies from calling their credit cards Gold Card. So now it's considered a generic thing that everyone uses because everyone's out there calling their credit cards Gold Cards. Now they figured, okay, gold isn't good enough. We got platinum and sapphire, but what can you do? All right. Notice of trademark rights in the United States. A trademark owner indicates ownership by putting the TM or SM for trademark or service mark. Once it is registered, only when it is registered can he use the R with the circle. If they use the R with the circle improperly, which a lot of people do, that is actually a violation of the law, and if the Department of Commerce finds them, they will fine them. You cannot use the R circle designation, without an actual trademark registration, which means they've gone through the whole process. Okay, E, client consultation. What's the proposed mark? Tell me what your mark is. What is it going to be used for? I need to know a list of goods and services that I put in the trademark application. Where will it be used? How and when will it be used? Is the basis for it to be refused? How likely is refusal will be challenged? Basically, what else is out there? I want to see what's a trademark, what are they using it for? What else is out there that looks, sounds, smells similar to their mark, and how close are the goods? How close are the channels of commerce? So we're going to go into that a little bit more with trademark clearance. And I also want to know first date of use. Because if they are currently using their mark, you file the mark as a currently in use basis, you submit a specimen of use. Reason for doing this is it will save them fees later. Otherwise, they have to submit the statement of use later with an additional fee. If they're not using it, you can file as an intent to use basis. They have to have, quote, a bona fide intent to use the mark in interstate commerce. If they have that, you check the box on the application, or you put it in, whatever, and then when they sign the application, whether physically or electronically, then it will, then they attest that they intend to use it. Maybe I'll pause here. Are there any questions on anything I've said thus far? Yes, sir.
At a university, there's a tendency to use letters to represent the university. Would it be a trademark or would it be a copyright?
Trademark.
Well, what about if the letters are specifically designed in a certain way?
I would do a trademark. You could do a copyright too, because that's now an artistic work. So you could do both. Generally speaking, people do trademarks. The copyright isn't really so worth it there. You could. I mean, if you're doing it and you're getting paid the same salary anyway, it's a $35 fee to register a copyright. Just to fill out the form, submit it, and that's it. Wait for it to come back as copyright registration. But the reason why I tend to favor trademarks over copyrights is copyrights are sort of amorphous. There's any sort of artistic work, and then it's a question, did they copy? It has to be a derivative work of theirs. If they developed it independently, it shouldn't be a copyright infringement necessarily. But with trademarks, anyone can go into the database, they can look it up, they can see exactly what's circumscribed in the trademark. Copyright, you can't do that. Copyright, I know a person has a registration, I don't know what the content is, because I don't want to share it. It's copyrighted. You can imagine every Pink Floyd song we're in the copyright office for download for free because I want to see what the copyright is, so we don't do that. That would defeat the whole purpose. But trademarks, it's circumscribed, it's there. The damages are pretty high for infringement. It's just much easier, much better to show. I mean, coming back to cease and desist letters, the strongest cease and desist letter you can write is for utility patent infringement. The next strongest is probably trademark infringement, for registered trademark. After that, it quickly goes downhill. Then is copyright registration. Then is probably design patent. Then is probably common law trademark rights. And then is common law copyright rights. And then all the way at the bottom is trade dress infringement, which is like the cease and desist letter of last resort. Client really wants you to write something. You tell them, well, you surely can't do this and this. Oh, I want to write my letter to stop. So you claim trade dress infringement. Trade dress infringement is actually a form of trademark protection where it's not even by statute, it's by the courts. Samara Brothers is a Supreme Court case on it, amongst others, that say that if the look of your product is so similar and so close that people are going to be confused and think there's an association, that's a problem. Where you really see that is in packaging trade dress, where the packaging for material, you go to CVS and packaging for one lip balm looks like the packaging in the other lip balm, that can be trade dress infringement without any registrations whatsoever. Hard to have a case for that, but there are real cases of it that are real substantial. In general, when people write this letters, they're rarely rare. They're really rarely real. I had a case that I dealt with. It was a Cuban restaurant. They had hired the same designer as another Cuban restaurant. And no association with each other. I think they probably had some workers that worked at one and worked at the other. But really no association other than they hired the same designer. So got a letter from a very big law firm, one that I actually almost respected until I got this letter, saying this is trade dress infringement, and they listed all the things that were same. I mean, there'd be like Cuban drums and pictures of the ocean. And my response was, it's a Cuban restaurant. Of course they have Cuban drums and pictures of the ocean. So, that type of thing. But they did have certain points and whatever. So we settled on it, we went back and forth, and he was a reasonable lawyer, but we went back and forth, and what we settled on was they would change the paint color, and they would change one of their fake palm trees to make it look a little different. They had like 2 or 3 fake palm trees. There was one of them they had an issue with. We decided the other 2 there wasn't an issue, and we took it on, and we did that based on trade dress. That really, in my opinion, was more on, it's really not worth it to pay $5,000 and $10,000 in legal fees fighting you. So, fine, you want us to repaint in the spring? I mean, we got a 6-month extension in there. We're like, okay, within 6 months of repaint, because it's winter right now, we don't want to repaint. So, they agreed to that. That was a case of, client's mad, you claim trade dress infringement. Anyway, that's just a side anecdotal story. But, all right, trademark clearance. Utility and necessity of a trademark search. So, basically, as they write here, it's the duty of an attorney to recommend the most comprehensive search available to domestic, in some cases foreign trademarks. That means, different attorneys do different things. So basically, I got 2 levels. I got the level for the guy who calls in on the phone and says, I'm calling around to all the attorneys, I want the cheapest price you could give me for a trademark filing. I tell him, okay, we can do what I call a preliminary search. Why do I call it preliminary search? Because I don't have much time to talk to him on the phone, because whatever, he's just calling around. So I say preliminary search to make it clear in 2 words. I can do a search for you, but there's something higher. This is preliminary. I can do a preliminary search for you and file. Some people call it a knockoff search, which basically means I go to the trademark office, I go to the trademark office database, and I search it. Anyone can do this, but there is an art to it, as we'll get into when we start talking about classes. So maybe over the break I'll try, I didn't request a screen, I should have requested a screen, to show how we actually do this. But you can go into the trademark office, USPTO.gov, you can do a quick and dirty search. Person says they're filing Sierra Mist, you go to the trademark office, you just type in Mist in the simple search and see what comes up. You're going to get 3,000 references with Mist in it. So then you narrow it down by the class and subclass. You figure out, well, they're doing food products. Food products are international class 29, 30, and 31. Each one, to let you know, has a different fee. If they're filing for all different types of food, in those 3 classes, they need to pay not 1, not 2, but 3 government fees. It's almost like 3 separate trademark filings. And anyway, you then narrow it down by class, you narrow it down by the goods and services, and you try and find what's there. I mean, that's something anywhere from 5 minutes to an hour on this type of search I'll do. And consultation back and forth with the client based on what's there. There's something at a higher level called a full clearance search. Full clearance search is, we want to make sure, so here's the problem. Even if I search the trademark database, perhaps someone has spelled it differently, but it sounds the same. I search with an S, they end it with an X. I search with a CK, they spell it with just a C, whatever it is. Or there's something that's kind of similar. I search for halo, and they spell it helo with an I, or something crazy like that. I didn't find it that way. You're not going to be able to figure every variation of spelling and so forth. I mean, you try. But that's why it's called preliminary, just to give them some idea. Now, when I have a more sophisticated client who says, I want to do this right, I want to make sure we're going to file this appropriately, and there's no way I'm going to have any problem with this trademark, I say, okay, here what we should do is called a full clearance search. A full clearance search, what that does is, some attorneys do them on their own. Personally, I just order them. There's companies that do it for varying prices and varying quality. But a full clearance search will give you, generally you get a book like this. It's like they give you this thick thing, and it gives you anywhere where anyone is using the name in commerce, basically in the whole country. These things are actually admissible as evidence in court. Someone sues your client later and says it's infringement or opposes your trademark, you say, I did my research, you were nowhere to be found, there's no problem. Comes up in discovery requests all the time. Involved in the case of Metaluca, they sent in a discovery request, send us copies of your trademark search. So the guy gives it to me only on paper. I sent them a couple pages, and hopefully they'll be happy with that. I sent them a couple pages because they know and I know it's really irrelevant to the case, but it comes up. It can be used as evidence where relevant. Anyway, and so what those are is they tend to do Soundex searches. They do corporate database searches in every state. They search periodicals and websites, that type of thing, to give you a complete picture, which then you as the attorney can review and more fully come up with a proper opinion. Is this going to be a trademark problem or not? So it depends on who your clients are. The people that call me off of internet, they tend to be like, nah, I don't want to do that. But more serious clients, when you build up a relationship, or if you're in-house especially, you probably do this already or should be doing this to make sure you clear a name. So the way big companies often do this is they'll go in their marketing department, they'll come up with 10 names. They send it to the legal department, they narrow it down to 2 names, or they order them. They order in what order they are for trademarks. Then the marketing and legal department fight it out and come up with 2 names that they'll settle on. And if you're doing drugs, it's even worse because you got to clear with the FDA. It's a different problem. And then they'll order full clearance searches of like the top name or top 2 names, and then to make sure totally. So sometimes I recommend this to clients. I'll say, I'll brainstorm with you, give me a bunch of names, I'll order them for you. I'll put them in order for you, and then we'll go full clearance from there. It really depends on the sophistication level and budget of the client. Really, it all comes down to budget most of the time. And sometimes names, one second, I'll get to you. Sometimes you have names that it's just like, I'll tell them, you don't need a full clearance search on this. You're not finding anything like this, it's not a problem. Other times I'll recommend it. Yes?
Approximately how much does the full clearance search run?
Varies widely on who you're ordering from in law firms, but Thompson CompuMark is up to about $800 on them. There's other providers as low as $300 with varying degrees of having good searches. Thompson does an excellent job, but they raise their prices every year. They got too expensive for me. So I found another place I'm happy with, which is Cardinal IP. I had some trouble with them at the beginning. I gave them a hard time, and they gave me to somebody better who does my searches now, I guess, and now I get much better searches out of them. So, it depends on your comfort level, understanding of what you're getting back from them, and, knowing if it's good or not, and that type of thing. But if you want to be on the safe side, I would say pay the money for Thompson CompuMark. They do excellent search results, but you pay. And then, I bill for my time in reviewing that report, because then you got to go through it and rendering an opinion. Any other questions? Okay. All right. All right. Let's jump to Roman numeral 3, the trademark registration application process, because I think I sort of killed everything else here. Okay, trademark registration process. So, introduction to the U.S. Patent and Trademark Office. Let's go proceeding for Roman numeral 3. So, what does it do? The U.S. Patent and Trademark Office reviews trademark applications to determine whether it meets the requirements for the federal regulations. Basically, what they are going to do is see, is there a likelihood of confusion? Is this confusingly similar to any other registration? Occasionally, they'll go out and do things like search Google. Not often, but they do sometimes, and will provide you with a rejection based on something else out there. They'll basically be if the trademark examiner feels like this name shouldn't be registerable, there's no trademarks here, but I'm going to do a little bit of a search. I've never seen them do more than that. They will search the registration database amongst other trademarks, and they'll maybe do an internet search. That's about the extent of it. Which is why you need that full clearance search, because there could be a store out in Idaho with the exact same name selling the exact same goods. They don't find it, you don't find it, and in that full clearance search, it would show up, and you could at least counsel your client about it. All right, and right, you can call them. The help desk is pretty good. U.S. Patent Trademark Office they're pretty good in terms of help and answering the phone and stuff. It depends who you get. Some people on the other end are more knowledgeable than others. If there's a real issue, you can have them refer you to the legal department. I've spoken to a lady in the legal department of the trademark office who was extremely knowledgeable, has given me great help, but I only call her sparingly, like twice in my practice, because you don't want to abuse such a thing, because they're not too happy about that, but they are generally very friendly and will answer your questions, and it's pretty well run. It's actually kind of amazing that it's government. Patent side, I have very different things to say, but the trademark side is very well run. All right, and otherwise, you hire an attorney, which is us, for real legal advice, that type of thing. You have a short, quick question, feel free to send me an email. I'm happy to answer short questions, that type of thing. All right, but the U.S. Patent Office, Trademark Office, they don't enforce your rights, they don't bring legal action, they really don't do anything but deal with what's filed and what comes their way. They're the government, they can do that. So if you want to make sure that there's not a problem, you need to be out there. You want to make sure someone's not infringing on your rights, you need to be watching and make sure that nobody starts selling products into your name or files into your name, that type of thing. If they file a registration with your same name, well, then they should reject it, but not always. They don't always see it, they don't always get it right, they don't always have the right opinion, the same opinion, I should say. So for that type of thing, you need to watch. I just filed a letter of protest yesterday, not because they did anything wrong, but because somebody filed a very similar mark to my client's, and I filed that so the examiner would be on notice about this other mark, make sure he sees it and it's clear, and hopefully he'll reject this mark that was just filed. And if not, you got to wait till opposition. You really have no say during the prosecution of the trademark of somebody else's. The best you can do is file a letter of protest, but if they allow it, nothing you can do. And then once it goes to publication, that's when you oppose someone's trademark.
I have a question.
Yes?
How are you monitoring someone else's trademark that was filed after yours? Are you looking at the register?
In this case, what happened was client has been in business since like 1993. They came to me and said, we want to do a trademark registration. And I said, why have you been doing this since 1993? And they said, well, because we want to get serious, we want to expand our brand, we want to do this better and become professional. And so while he was in my office, as they're negotiating price and want cheaper, I did a search and said, no, this is going to cost you more. I'm doing the search, and I found another one. I'm doing the preliminary search, and I found another one dead on. Same name, same products, but they just filed and they just claimed to start using it. So since it hasn't been examined yet, that's how I knew to file a letter of protest. Now, what should be done, and I put this in every one of my trademark issuance letters, and very small handful of clients do this, but what should be done is trademark watching services. Thompson's CompuMark, Cardinal IP, these places. You could do it yourself. It's just not cost effective usually for a law firm to set up the what they need to do this themselves. But the U.S. Patent Office has an official gazette where they publish this stuff, and these databases are all searchable online. So you can actually, for a couple $100 a year, they will send you, using like one of these IP companies, they will actually send you notices of anything which is filed or published or whatever you order that's similar. And that's how you know. And then you forward it to the client and say, here, look at this. Do you want to oppose this? Do you want to send them a letter? If you file, for example, anything with a horse in it for clothing, you will, in fact, get a cease and desist letter from Ralph Lauren. It will be a robo cease and desist letter, automatically faxed, sometimes with the right heading, sometimes with the wrong heading, having received these before. And they will just, as a matter of course, oppose anything. They're looking in the database, they're watching, and their law firm will, as a matter of course, send out a cease and desist letter to anyone who doesn't and oppose any mark. And that's just what they do to protect the name. And they spend tons of money protecting the horse on clothing. Whether they're right or not, whether they win or not, bottom line is in a case like that, it comes down to who has the most money. They're willing to spend tens of thousands of dollars, if need be, on a legal case fighting it. And someone who's just starting up with their business, selling some t-shirts or whatever, is not willing to, for obvious reasons. It's not worth it. So that's the way it's designed. It's sort of Coase theorem. He who has the most money will end up having the rights because they'll spend the money to get that rights, and that will determine the worth of something, except for the fact of transactional costs. So here the transactional costs, I don't know if anyone's familiar with Coase theorem, but it's a theory that basically says, he first proposed it for radio waves, for who will get the rights to a certain frequency of radio rights for radio broadcasts. And eventually the person who wants it most will get the rights because they'll be making the most money and have the most money to spend on it. Except for transactional costs, the cost of acquisition, dealing with lawyers and recording stuff and buying people out and that type of thing, which sort of hinders a perfect flow of such a system. Otherwise, the trademark system, in my mind, works pretty much the same way. You want the rights to a name. He who has the most money is generally going to be the one who wins out and ends up with the name, but for transactional costs, when you're dealing with a big company versus a startup, the person who has the most money is going to end up having the rights to it because they have the most, they care about it the most. I don't know if that made sense or was totally off topic and shouldn't have bothered, but anyway. Okay, any questions on Coase theorem or trademarks?
So the trademark watch service is available per name. So basically,
Yes.
you're billing per client. Okay.
Yeah, per client, per name. I mean, individual names type of thing. All right, so now we get to electronic filing. This is B. So based on length of time, even an electronically filed trademark application can take for the, I'm not sure what that sentence is, but basically, you can get a serial number right away. If you file electronically, it's right away, it's easy. I don't see any reason not to. You can also get a reduced fee payment. You can also use the trademark identification manual to select goods out of it, like automatically. It's all part of the electronic system. What used to happen in my old law firm, where I was working for somebody 50 years older than me, he would file on paper, and you would list your goods and services in the application. And then you typically get a rejection where they would say, well, we don't like the way you wrote this. You wrote it as, I don't know, buttered popcorn. We want to say popcorn having butter, something like that. And in order to match the identification manual, it wouldn't be that bad. When you file electronically, you do a search, you select the goods, you get a reduced fee for doing it that way, saves from such a rejection, makes client happier because their bill is lower, although they don't always know it because they don't know what happens if you don't file that way, but point being, it still streamlines the process and makes it easier for you to get the registration. I suppose you might make a counter argument. Don't use that system. Type in your own thing and let it get the rejections. You bill the client more and say, look, I fixed it up and got it through for you, but I don't do it that way. I select from the ID manual and I like them going through as simple as possible and make it easy for the client. All right, and then this talks about the fees. The $275 is called T's plus when you do select it from their list of goods. And it's just called T's when you file electronically. Without that, it's $50 more if you just use the regular T's and not the T's plus. All right, owner information. The application must be filed in the name of the owner of the mark. So the owner is anybody who owns it. That can be an individual, it can be a company, it can be a foreign company, it can be a partnership, it could be anything. You can have multiple signatures if it's owned by two different people and they both have ownership rights. I don't recommend it. Whenever you have individuals without a corporate formation of some sort, without corporate governance, they tend to fight. You tend to have to recluse yourself because they start fighting, they're both your client, and that's just not fun to deal with. So I recommend that people file an LLC. Not for today's topic. It's simple enough to file a New Jersey LLC. It does not cost that much to do. And makes it a whole lot easier for them to do business anyway, because they have a separate bank account for their business and whatnot. All right. trademark, this is letter D, description of information about the trademark. So a standard character mark means basically I file just the words alone. I just type it in. That is different than, basically this is A and B is basically just saying in very long form it is a basic trademark with just words. You just type in the words, no fonts, no special stuff, no specific size, it's just a name, the name Coca-Cola. That is, in contrast to two, a special form mark that would be the Coca-Cola logo. The logo, a designed logo, anything in that form, is special form. The difference is you have to submit the image to the trademark office when you file it. So that typically means upload the JPEG or PDF, or as we used to do when filing it on paper, we would actually tape it on a separate page to the trademark application itself, and they'd scan it in at the trademark office.
I have a question.
Yes.
Isn't the word mark the best kind of mark to have? Because can you just like use the word mark and then switch, different logos with it? I mean, I guess what I'm asking is, when is a logo and when is the logo a trademark?
Yeah, the answer is yes. A word mark is usually preferable because a word mark protects anyone using that name regardless of what their logo is. However, there's two reasons to do a logo mark. One is a logo mark extends your protection. Suppose someone has a similar logo, but their words are totally different. Like the copyright infringement, you've registered the copyright, but you want it to be trademark infringement. As a general rule, if you can make a trademark infringement, it's a better bet. It's much scarier to people. Much harder to come up with legalisms to argue around it. So, if, for example, someone has, instead of Sierra Mist, they have the same font, the same green, the same size, same color scheme and everything. They're selling soda. There's no issue with that. It's not confusingly similar goods. But instead of Sierra Mist, they write, who makes this? Is this a Pepsi product? We can talk about Pepsi's attorneys too. They're as bad as Abercrombie and Fitch's. Anyway, yes, this is a Pepsi product. So suppose Coca-Cola, they come out with, Sierra Sprite Natural. Technically, that's not infringing on the word mark. Or let's put it this way. They make an argument it's infringing. It'd be harder to prove infringement there. But on the logo mark, since it looks like the logos, it's the same green, the same font, same style, now it's a hell of a lot easier to say trademark infringement on the logo. So generally, I recommend filing both the logo and the word mark. And there's another reason to file a logo mark. Suppose your client can't get the word mark. Suppose the name of your client's product is, I have one that that right now is precontract.com. They could not get pre-contract because what they're doing is selling a service which is a pre-contract. I'm not going to get into what their service is, but they are able to get the logo mark. So we filed the logo mark because they could get that specific logo. It had red, white, and blue, the flag, and stars, and everything. That they could get because it's a very specific logo. We filed that. I've also done the backdoor approach. I have a client, EasyWipe, EasyWYP. They're a type of wipes. Filed the logo mark and the word mark. They were both rejected. I filed a whole brief to get over the rejection on the logo mark first. I got the logo mark through. Once I got the logo mark through, called up the examiner and said, hey, you allowed the logo mark, or same examiner, allow the word mark. Should be the same. Why did I do that? Because by arguing on the word mark, I have far less arguments. I can't argue that the logo looks totally different than all the other easy wipes out there. But now that I've done that and got it through, I then afterwards argued the word mark. You could also, sometimes I just plain old file the logo mark first and tell the client in 6 months we'll file the word mark. And I'll probably be able to get it for you. Just, I don't know, human psychology. It's just once you have one mark, they're more likely to grant the second one. So it's sort of a backdoor approach to getting the word mark.
But then you have to use the same logo. And do you have to use the same logo on, say it's a service mark, on every single piece of...
No. It just has to be used somewhere. It doesn't mean you have to use it everywhere. As long as you're actively using that mark in interstate commerce, it's fine. There's no minimum of uses to get a registration, or to maintain a registration.
So if you had like a word mark and you had a logo,
yeah,
you wouldn't have to necessarily use that particular logo with the word mark all the time? Do you know what I mean?
You could use a different logo.
You could use
a different logo, but your other logo obviously isn't protected by a trademark
Right,
registration.
okay.
Only that particular one is protected by a trademark registration.
Okay.
All right. Any other questions on this? Okay. Am I boring you with my long-winded examples, or? Okay. Polite crowd. All right. So on the mark itself, on the next page, top of page 12, he says you shouldn't include the registration symbols. The truth is, you can use TM and SM. Well, do they? I think he's right. No, he's right. You shouldn't use TM, SM, or especially not an R with a circle on it, because R with a circle is just plain old illegal because you don't have a registration yet. But you shouldn't use TM or SM. That's not part of the mark itself. They just want to see the mark itself. Unless a color image is being submitted for a mark, where color is claimed as feature, the mark image should be black and white. Reason you do this is if you're submitting a color mark, you're saying that it's that color scheme, which is good because now it's clear that yours is green, and if someone else has green, it's clear it's a problem. It's bad because if someone is red and it looks the same, you could say, hey, it's harder to show it's confusingly similar. So you can submit a black and white mark, and you can just protect it in black and white without any specific claim to color. That you can do. I think that's really a holdover from back when people didn't upload JPEGs and had black and white printers. But you can still submit a mark in black and white. Generally, I don't do it. I submit the color mark and submit it as it is because I guess it's just easier that way and raises less issues. And we work in color today, and I think it's what clients want to see. They want to see their actual mark registered. But there's reasons why you might want to file black and white. I don't think it's done very often anymore. All right. Goods and services description, as we described before. These are all the goods and services that are in there. So, example of goods, bicycles or candles. Example of services are bicycle rental services or catering. In other words, so in one of the trademark classes, you do bicycles. In one of the service mark classes, you would do bicycle rentals. You might do both for an additional fee. Thank you. Additional fee. All right, and then this is talking about the manual. I already spoke about that. All right, and then, okay, now let's get to classes. Part 4, he only gives us one number there, but I think this is really very important. There's international classes that are used in the United States. When I say international, it's nothing to do with an international trademark filing. We're talking about U.S. trademark filings, but this class system is used around the world. So, for example, class number 29, 30, and 31 are different types of food products. 30 is baked goods, 29 is like fresh fruits or something like that. I don't remember exactly. 9 is computer software and hardware, MP3 downloads, websites, that type of thing. But now if you have a website offering services in connection with who knows what, that's usually class 41, 42. 41 is educational materials, 42 is, I don't remember, it's some sort of other service that's generally associated with websites. So it's very important to know what class it's in. Reason for this is how the government makes more money. If you are filing, as we gave in the example just above, bicycles and bicycle rental services, you're selling bicycles and you also rent them out, that is 2 different classes, 2 different fees. Last week I quoted a client a price on the phone and told him it was for one class of goods. He said he was filing textiles. I said, great, textiles, one class of goods. Then it gives me an email with a list of 8 different types of products in 6 different classes. And then I had to explain to him these are different classes, more fees. But you told me the price was X. I said, you told me you had textiles. You've now given me, for example, mats. If you have a placemat, it's one thing. If you have a floor mat, it's a different class. If you have a placemat made of paper, it's one thing. If you have a placemat made of fabric, it's another thing. In Europe, they give you the same price for up to 3 classes. United States, it's an extra fee for each class. Now, you might say Europe, hey, that's better because they're not nickel and diming me. They give me 3 classes, but filing a trademark in Europe costs about 4 times as much. Europe is generally much more expensive and much more bureaucratic. The U.S. Trademark Office is relatively easy to deal with as long as you're willing to keep paying. Thank you. Alright, filing basis, I spoke about this a little in the introduction. An in-use mark is for one that's currently being used in commerce. You have to provide the date of first use in interstate commerce. They got to know the date of use because that's going to show you priority. That's useful. What's actually tends to be more important is your filing date. Who was the first to file? You submit a specimen showing how it's being used for goods. You submit a picture of the product, so a hang tag. For example, if you're selling coats, then the tag on the end of the coat that says Jose Bank on it, you submit that. For services, you submit, usually like advertising works there. Advertisements don't work for goods, advertisements work for services. Something showing how you promote your services. All right, intent to use filing basis is, we've discussed that ad nauseum before. Foreign filing basis, this doesn't come up too well, it depends who you are. For the people in this room, I don't think it would come up too often, because this is somebody who is using the mark in another country, they're extending it into the United States, and they're claiming the priority filing date to their foreign mark, which provides fun issues when they come in using it later, but providing a priority date earlier. I believe there's actually still a circuit split amongst the courts who gets priority in that case. I think it's something like almost all of the circuits rule that the foreign one would get priority from the earlier date, and I think there's 2 circuits that say no, not the foreign one, the whoever uses it first domestically. I don't think that's been resolved yet. I think it's still an issue. Application filing fees, we discussed, $275 for the use their identification manual and check the boxes and search. $325 if you are filing it without that, you're free-form entering the goods and services. Sometimes you have to free-form enter the goods and services. I can't recall the last time I had to do that. It's not in a long time, because what they've done, I'll get to you in 1 sec, is they've left open blanks. They'll say, website services in the nature of blank, and you can fill in the blank even with the $275 fee. If you file on paper, it's $375, because who wants to deal with paper? They have to have some paralegal there or someone scanning, typing it in to make sure the data is right. Where if you file electronically, it's all populated in their system and they can very easily deal with it. Yes?
As far as the specimen is concerned, if you have someone who does consulting services, they kind of started on the whim because someone asked for their services.
Yeah.
They didn't have any advertising. What would you use as a specimen if you had to go back?
How did they tell their client their name? How did they let them know who they are?
Probably a letter directly to that client, because it
The
wasn't
letter is sufficient. There you go. The letter on that letterhead. Yes, I've submitted that successfully. Which one was it? It was something like, sorry for all these references, but it's something like Chief Rabbi of the Bulgarian community or something. And to submit a specimen, I just basically took one of his letters where it was on his letterhead and submitted it. And that was it. They accepted that as being used in commerce.
So then the other question is, if there was consulting services or as you say, that the educational services are in 2 different classes, 41 and 42. If that item that they did 2 or 3 years ago to that one client was in class 41, but now they're starting to work in class 42, what do you use as your first day of use?
Okay, that opens up a lot of questions. Okay, first of all, let me preface by saying the classes often overlap. And it often really doesn't matter what class they're in, as much as it matters what goods and services are listed. I don't remember offhand what the difference between 41 and 42 is, but
let's say it was educational services and T-shirts. So
okay, that's very different. So, okay, fine, let's go with that example. That one's going to be an easier example to explain. T-shirts would be clothing class 25. Educational materials is class 42. Very different. One's a good, one's a service. Very different things. So what I would say there is, well, you're running up against another issue. A trademark is presumed to be abandoned if not used for 3 years.
No, what I'm saying is they're still doing the consulting services, but now they've decided to add T-shirts too.
Oh, okay, they're trying to add it. Okay, fine.
Consulting 3 years
Okay,
ago.
I'll get to that. So, just to finish the point of abandonment, if they're abandoning use, then they wouldn't use it. Then they might not be able to file anyway. But if they are currently using, then you would file in both classes. Now, I'm going to go through a bunch of different iterations, just let me get there. So what you would do is each class has a different date of first use. So suppose I started using class 42, then I would say, starting in 2007, my first date of use. I add on T-shirts in 2012, that's fine. I can file it together, legend 2007 for this, 2012 for that. submit a separate specimen of use for each class. Each class needs its own specimen, not the same one. Then, more than that, suppose I had filed in class 41, it's registered already. Now I want to add class 25, or even if I want to add more goods in class 42, I cannot do that. I need to do a separate trademark filing, and in that separate trademark filing, get a new application serial number, a new registration number, and list the new goods. Once it's filed, that's it. There's no going back and adding new matter. But if you're filing the first time, you can file as many classes as you want, and they don't have to be the same dates. So I hope that more than answers your question and anything tangential to it.
So even if I'm using...
No. Okay.
So even if... I understand that you said you have to go back and do a separate application.
Yes.
But it could still be the same name, just a different
Oh,
class.
absolutely.
Okay.
Yeah. You own rights to the name, and you put in there's actually a spot where you reference it, or on paper you would type it in, but you'd write it in. But when you do electronic system, you reference the prior registrations on that mark to say that you own the other registrations, and you're basically expanding what your trademark covers. Now, just to jump ahead a little, because I started touching upon it, trademark infringement is a likelihood of confusion. This is something that clients and worse, attorneys screw up all the time. Just because I'm in class 41 and you're in class 45, whatever it is, does not mean there's not trademark infringement. The issue is likelihood of confusion. If you have a website which is giving manuals for teachers, and I have a website that's giving, with the same name, that's, I don't know, giving information about the space project, information about docking with the space station, it does not mean that there's not a likelihood of confusion. Likelihood of confusion is based on how similar are the names, how similar are the goods, how similar are the channels of commerce, and our consumers, what it ultimately comes down to is a 12-point test, which means there is no test. It comes down to is, are consumers being confused by that name? And we go through the 12 points, the sleek craft factors as they're called from a case. And we go through and see, is there confusion? Having a different class is sometimes helpful, and sometimes let's make an argument that, hey, it's a different class, but it really matters little what class you're in, and especially when they get really close. Especially if you're in food products for bread and someone else is in food products selling apples. Bread and apples are sold in the same supermarket and the same aisle sometimes. So it's the same channels of commerce and it's the same name. The person's going to think it's the same company. So there, sometimes you might tell the client, I got a client, he wants to file in 8 different classes. It's not making any money either. It's a different story. It's something he wants to start doing. It's not worth it. It's just not worth spending that money to file in 8 classes plus the attorney fees to do all of that for something, because if he's selling bread and t-shirts and they start selling apples, it's infringing nonetheless. So you don't necessarily need to be in every class, but you want to cover yourself substantially enough that anything that's going to be problematic is going to be a likelihood of confusion. All right, any questions on that? Okay. So the international class system, the moral of the story is it comes down to, it gets the government more fees. It doesn't help you or hurt you with infringement. It just entitles you to pay the government more money to say you have something broader. And what you see a lot of times is like Japanese companies will come over here. They got this super long list of goods and services. It's something cultural, I don't know. And they have it in 8 different classes, just going through these things. There's tons of things. Well, the way you deal with something like that is there are actually cases at the TTAB, the Trademark Trials and Appeals Board, where they have said if any one thing in that mark is not actually being sold and you assert that it is, that is fraud. And if you have fraud, you have no right to your trademark application. So on the other side of this coin is you need to be careful what you list in your application and not go too broad, because if you list things that your client isn't actually selling, you have a duty to cancel those things from the trademark. If you do not, then it is fraud, you can lose the whole mark. So when Denso Corporation, I think that's who it was, sends a cease and desist letter, they assert this trademark that they haven't used in 3 years and has 150 different goods and services listed in the trademark application. Somewhere my response is, oh yeah? My client's not infringing. We don't believe there's any confusion. And further, after we go through that, I don't believe you're selling all of these things, and I believe your trademark application is fraudulent. If you'd like to continue this, if you'd like to take us take you seriously, give us a sample of where you're selling each and every one of these products. And this was a new attorney, I think, had taken over from the last one who hadn't touched it in 5 years. So I never heard from them again. I don't know if it's Denso or one of the other ones. But it's safe to say that they're not going very far with that. It looks very big and it looks very powerful to say, look at this trademark and all these classes and all these goods, but you better damn well be selling all of those goods, because if not, if you come across an adversary on the other side that knows what they're doing, you're going nowhere and it's only going to hurt you to file too broadly. So the moral of the story is, do it honestly. Do it honestly, do it right, and in general in life, that's what will get you the best thing in the long run. Even if you're going to scare some guy in the short run, it's going to cost you more money. In the long run, you're going to lose. All right. Publication, attorney's role after the application is submitted. Check the application every 3 to 4 months. There's a great program out there. If you start filing a significant number of applications, it's called Feathers. It's put out by Opendale. He's a law firm in Colorado. He puts out this piece of software free for any attorney to use that it just basically pulls from the trademark database and gives you status updates for all your trademarks. So you can see what's going on with them. I get stuff by email. I've never missed an email from the trademark office. They've always come through. The process takes about a year, could be longer. If you get a rejection, you have 6 months to respond to it. They take longer. Generally, if things go right, if things go through properly, my trademarks take about 9 months to a year from beginning to end. You have 6 months to respond. Generally, I bill the client right away, or I just do it right away and send them a bill and say, here it is. And if you do your research right, you know what you're up against. I haven't had an outright likelihood of confusion and rejection in a long time, because if you do the research right, it'll just basically be minor things. You have to describe the logo. So your logo is this. You describe it as the word Sierra above the word mist, above the word natural, all in green with Sierra smaller than mist and natural. They'll come back and say, I don't like the way you worded that. I want you to word it some other synonymous way. And I generally say, yeah, sure, no problem, because who cares how you describe the mark? What matters is the mark. And you deal with issues like that. Or they'll say, I want you to disclaim a certain word. I want you to disclaim the word natural. You can't claim the word natural even though it's on your logo. So you don't actually disclaim it totally. You say, I disclaim the word natural apart from the mark as shown. It's still part of your mark, but if someone else calls their product natural, you have no right to sue them. All right. Office actions. Approximately 3, cross that off and write 4. That's what the trademark office claims. 3 months, it's not. It's 4 months. It's been 4 months for the past 5 years. From the date your application is filed, the examining attorney will determine, they'll basically examine it. And they will see if it satisfies all the requirements, as we've been discussing. They may issue an office action. You have 6 months to respond to deal with any issues. The 2 types of refusals are 5 and 6. The substantive ones, likelihood of confusion. It's too similar to somebody else's trademark. It's generic, it's descriptive. If it's generic, if I'm calling it tablecloth for a tablecloth, it's generic, there's no way you're getting that mark. If it's descriptive, if it's pre-contract, then what will they do? They'll say, you can get this on the supplemental register. The supplemental register is a place where you can get a registration for basically the common law rights. You can't get attorney's fees for infringement. You can't get statutory damages. You get basic actual damages. It's basically just to say, I have a registration. It scares people a little more. You can use the R with the circle. That's oftentimes all people want. And it also enables you then to file internationally. The reason why they actually created supplemental register was the rights in other countries are very different, but you need, and oftentimes in other countries, to file, you need to have the registration in your country of origin first. So they allow you to have the registration, so you can then take this internationally and get a full, what is the equivalent of a primary registration in other countries. Surname rejection, I got one of those ones. Zoning Language Labs is one of my clients, and actually around the world. They're based out of Manhattan. And the examiner, sometimes they issue an office action in writing. Now, a lot of times I find they just call on the phone, or sometimes they'll just email me, like give me an informal email. Can I change it to this? And be like, yeah, sure. They're very easy to work with in general. Occasionally you get crazy examiners, but usually they're easy to work with. So this examiner called me up and said, Zoni is someone's last name. And he said, I've actually already done the research, and I know that your client doesn't intend to use Zoni as a last name, and it's an acronym for each of their last names in turn. It's a made-up word for Zoni Language Labs, but still it is someone's surname, so I can't allow you to use it. And I said, come on. And he said, okay, I've done further research. I've actually looked around, probably using Google Translate, and I found out that Zoni is a type of soup in Japanese. In Japan, it's called a soup. So if we put on here that Zoni is a type of soup in Japan, you can get your mark registered. I said, okay, let's do it, thank you. What are you going to say? No, I'm going to fight you on that and spend tens of thousands of dollars up on appeal to get this mark allowed. Put the statement that says it's a type of soup. Mark allowed. Another case, Aslan Coatings, A-S-L-A-N. This is in fact somebody's last name. I got the counter rejection. They said, well, you need to put the translation for Aslan. Who knows what the translation of Aslan is? Anybody? Nobody here is from Turkey. The translation of Aslan is a lion in Turkish. Now, I happened to do a search on this because I was like, come on, and I looked at other trademarks for Aslan. None of them listed lion as a translation. Why did this trademark examiner tell me that I needed to put a translation of Aslan in Turkish when no other trademark ever had to do that? What is different that you can do with trademark filings today that you couldn't do even 5 years ago to figure out these translations?
Google Translate.
Correct. You go to translate.google.com, you type in Aslan, it says auto-detect lion in Turkish. So, that's the kind of stuff that happens. And so, we put the translation on. I argued, I was like, come on, none of the others have blah, blah, blah. I get it with the examiner, I was telling you to stand on that. Yeah.
So you're just putting that translation on your application as additional information?
Yeah, it's additional information. On the certificate itself, it's just an additional line added on in all the text. Nobody cares. It doesn't, as far as I know, it doesn't affect the rights whatsoever. Well, actually, yes, it does. This is the reason why it matters. Everything that's filed is supposed to be translated into English. I have a Russian client that I'm in the process of filing a trademark application in Cyrillic. I have no idea what it says. I call it encrypted. He gives me an encrypted application. My last name is actually Russian, and I get Russian clients calling me saying, do you speak Russian? I'm like, I'm sorry, the Feigins left Belarus, what's now Belarus, 100 years ago in 1903. But anyway, to me it's encryption. But you have to provide a translation, because even though he's selling to the Russian community, obviously, and he's using that name, it could be confusingly similar. Suppose he's selling telephone calling cards. Suppose his telephone calling card says AT&T on it in Russian.
The activity code for this session is 717252.
I don't know that, but that's going to be confusingly similar to Russians who are buying it. So for that reason, on all marks, you're supposed to put the translation. Now, my Aslan guy, there could be a guy who's calling themselves Lion Coatings, and ostensibly that could be trademark infringement. So in this case, it probably only helps because now nobody can call themselves Aslan Coatings, and they call themselves Lion Coatings. Where it hurts you is where the translation, I'll give you another example, I have Noi, this is a Korean client, is Noi, which means, I think nothing in Korean, come to think of it. That means us. Translation in some language, I don't remember which one means us. I don't know. Anybody? Alright, whatever, it's like Italian or something, I don't remember. You learn all these interesting foreign words when you do trademark applications. And that mark is currently sitting suspended, which I need to check on that, come to think of it, because there's another prior applicant who filed a mark for us for the same goods. So, you try and make these arguments. Nobody who's buying the product is looking at the translation. Nobody is seeing this on the translation. It usually doesn't get you that far. I'd love to appeal one of these cases, but I've yet to have a client that wants to spend the money to appeal a case like that. They just, you put it on, whatever. Or in this case, it stays suspended, and they're like, whatever. All right, any other questions on that? Yes?
I just want to mention that I received an office action for punctuation.
Office action for punctuation?
Punctuation, because I included a colon on the application, and it was not in the samples.
Okay, that's different. Your mark differed from your specimen.
Yeah, but a colon?
Yeah. Oh yeah, they're serious about that. However, they wanted to match. I mean, it makes sense. If I'm searching the trademark database, I'm searching by the words. And if I search the word and it doesn't match what's on the logo, it makes sense in that sense, but the colon has absolutely no bearing on a trademark infringement analysis.
The words are there.
Punctuation, plural, singular, doesn't matter. .com at the end, these things don't matter. The at the beginning, spelling with an S or an X at the end, it really doesn't matter. But they do want it to be accurate. I mean, I agree with that, it should be accurate, but for something minor like that doesn't matter, if your specimen turns out not to match your application, they'll allow you to change it either way. They don't give you a hard time about that. And I've done that. I've submitted it where it was like with the space, and then the specimen, later when I file a statement of use with the logo showing how they're actually using it, has no space between two words. And they'll say, okay, but amend it. Sometimes they'll just amend it for you. I've noticed that. They won't even issue an office action, just amend it for you. It depends on the examiner. It depends, it depends if they're laid back. It depends if they're whatever. It's personality, I suppose. But something like that, you just do it and be done with it. It's like stuff not worth fighting. All right, we are at 2:30. What time is the break supposed to be? 2:35? Okay, good. How far am I supposed to be at 2:35? 2:35, I'm supposed to be done with trademark prosecution. Okay, good. I am right on schedule. Okay. After we go through all that, and you've gone through the trademark office, and they said, okay, great, your mark has passed everything that the examiner thinks it needs to pass, we are now going to publish it for oppositions. This means practically, you wait about 2 to 3 weeks till they issue a notice of publication, and they tell you it's going to be published. They tell you it's going to be published in another 3 weeks. About 6 to 8 weeks later, you have a trademark published in the official Gazette, which most times it means you wait 30 more days until it passes. Then you wait another 2 weeks to a month till they either give you a trademark certificate if you filed your statement of use already, or they give you a notice of allowance and tell you you have a 6-month window to file your statement of use. I'll get to the statement of use later. Will I get to it later? Let's talk about it now. So what happens here, well, let's go in order. There's actually a timeline on my website. If you go to patentlawNJ.com/trademark-timeline. Again, it's patentlawNJ.com/trademark-timeline. I explain what I'm saying in plain English, and I have a nice graphic that I drew up myself that shows what happens at each timeline and how long each step takes. And what happens is when it goes to publication, if you're a horse for clothing, you're going to wait for your cease and desist letter from Ralph Lauren. If you are precontract.com, you're just going to wait out the 30 days in all likelihood. Most cases, you just wait out the time. And then what happens is you'll either get your trademark certificate or you're going to get a notice of allowance. And with that notice of allowance, they give you 6 months to submit the statement of use showing its use in commerce. If you want to extend, you can for a fee. Thank you. Can I get it from this side? For a fee. Okay, let's do it. No, I'm kidding. Okay. So what happens is it's $100 to submit the statement of use. An extension is $150. What I do is I tell the client, it's $350. I don't care if you do a statement of use or an extension. I'm going to eat the $50 if it's an extension because I'm doing $50 less work or whatever. So, and I just do it the same. And they can extend every 6 months for an additional 6 months up to 2.5 years. So meaning your total time from notice of allowance to the last day you have to submit the statement of use that you can possibly do is 3 years. Well, 2 years and 364 days. But you can actually get extensions more than that, but you have to then give an explanation why you need an extension longer than that. I don't know how often they grant them, having never had to do it. 2.5 years. I had a client with 2.5 years and said, come on, already give me something. When at the end, and he said, okay, fine, here's my website. So that's how that works. If you forget, you file a petition to revive. Petition to revive costs $100, and then you pay the extension fee anyway, and I just pass it on to the client. Because I, of course, send them reminders, and it's in my billing system, and it sends them automatic things that their invoice is overdue, and if they still don't file, then that's they get to pay more fees. All right, opposition to cancellations. Notice of opposition, this is when it's in that publication period, they can oppose it. You have 30 days, you can extend the opposition period to 90 days. Some companies do this as a matter of course, extend to 90 days and never file anything because they want to look into it and think about it. During that time, you can negotiate, they can threaten you can threaten them, you can marry their daughter and everything's okay, whatever it is. No, I haven't done that one yet. It is a good settlement strategy, so I hear, but I wouldn't recommend it. All right. They can file because they have to have, basically this is the court equivalent of standing. They have to have some standing in the case. They have to say it will harm them for this registration to be allowed. They don't have to have their own registration. They could just be a company that says, I got a store at Milwaukee, and this is going to harm the rights to my store, which has the same name. They could say generic, descriptive, false suggestive, they've abandoned it, it's fraud, whatever it is. Decision cancellation is up to 5 years after registration for abandonment or fraud. In other words, the reasons you can do a petition for cancellation after it's issued become much less. It's harder to oppose. So my clients want to go after someone and their application is still pending and tell them keep quiet. Don't say anything to the registration. I'm not sure this is correct. I'm not sure he's totally correct. After 5 years, what happens is, I'm not sure he's totally correct on the reasons that you can petition to cancel. After 5 years, you file further affidavits in the trademark office, and that is, one of the affidavits is an affidavit of uncontestable use. Once you've been using it for 5 years and had the registration for 5 years, then your mark becomes uncontestable unless there is fraud or abandonment. Before those 5 years, I think you can still say genericness and descriptiveness and so forth. And in fact, you can still say genericness after the 5 years. Anyway, if that issue comes up, call me, I'll look it up, and I'll apologize for not knowing those off the top of my head. I just don't deal with before and after 5 years distinction on petitions for cancellation very often. But there's certain rationales that you can do that you can't do later. In other words, your trademark becomes more solidified. If you don't have any filing, it's not very solid at all. You file it, that's a little better. You got a first filing date, the registration system. If it's registered, even better. After it's registered, then it becomes incontestable, that's even better. Otherwise, it's the same, it's a whole legal proceeding back and forth. Trademark maintenance, next page. Roman numeral 6, how am I on time? Ouch, how did I just do 8 minutes? All right, real quick, and then we're going to go on break, is you have to file, I'm going to not go into the details, but point being, you have to file a certain affidavit between the 5th and 6th year of use, Section 8 and 15 affidavits, between your 5th and 6th year of use to keep the mark alive, and then between the 9th and 10 year and every multiple of 10 starting the preceding year, meaning between 9 and 10, 19 and 20, 29 and 30, you have to file fees with the government to show continued use. You have to police the mark yourself. You can lose rights to your mark merely by not stopping infringers. You need to stop infringers to maintain your mark. You really have no choice if you want to keep your mark valid and in full force. Because once everyone starts trading off of it, it's not worth anything. It's akin to, you have property, you have your 100-acre homestead, and you own the rights to it, but you let the weeds grow on it, and you let all of the squatters come and take your land, eventually it's taken by adverse possession. The same sort of analogy works here. All right. It's not quite adverse possession, but same idea. Ethics and trademark registration process. Recommend the search. Tell the person you need to do a search. Don't promise them it's going to go through because you don't know it's going to go through. Even if you're sure it's going to go through, you could get a crazy examiner or find some reference that you just did not find. It's possible the reference that you didn't come to the full clearance search and it'll be found either in examination or you'll suddenly find out when you get a notice of opposition. Be competent. I mean, I think that's obvious. Competent review of everything. Make sure you're doing it right. Make sure there's no problems with other trademarks. I just tell the client straight out, I think this might be a problem. I generally go forward anyway, but I've done my duty, and then they come back to you and say, you were honest. You were the only attorney that told me the truth. The other one said, sure, I'll do this for you, of course. But you went to me and said, don't do it, so I hired you. I'm serious. I've had that. More so with patents. With patents, I tell people, your invention is not getting a patent. But if you really want to do this, I can extend your patent for like 5 years till you ultimately you run out of money on rejection. Shook my hand and said, you're the attorney I want to hire. Every other one told me it was a great idea. Now, the weird thing on that is he ended up getting a patent. And you can look at my website where I have all my patents listed. You can see I actually did issue, but I did not think it would issue. So anyway, that's it. I mean, just tell the truth. Put it in writing to keep yourself out of trouble. And let us stop there. We will pick up again after a 5-minute break. come back at 1:45. And if you have any questions, feel free to come up and ask me. Oh, I'm sorry, when are you supposed to have a break now? Wait, 2:55. Oh, no, I'm reading this wrong. Never mind. Oh, come back at 2:50. Come back at 2:50 and then we'll be right on schedule. All right, so we are on the ethical stuff on page 18. Communications with clients and other parties. This is basically the same as any other legal thing, is confidentiality. You have to act with diligence and promptness with the client. Don't take too long, that type of thing. Conflict of interest, where your representation will be adverse to another client, or significant risk in your ability to consider, recommend, or carry out because of a former client or that type of thing. One issue that I had come up is where they will, even though there's really no conflict now, it's still, well, I shouldn't say there's really no conflict, but there's no adversarial thing between the two parties. They likely will be adversarial in the future. So there I was once told the ethics thing to keep away from that. But on the other hand, I was told I actually had, this is a real case, I had a client that has done a couple things with, they had me send a cease and desist letter. I sent it to the other party. The other party says to me, I once came in for consultation with you. Don't you remember me? How can you send this to me? I did not remember him whatsoever. So I went and I called him to the end of the line and said, what do I do? I said, well, what did he come in for? He said he claims a patent application. I really don't remember him at all. And well, what are you sending him? Cease and desist letter on copying a design. This is one of those trade dress letters I love. Anyway, I said, well, if it's not related to that, if the thing that a potential client came in for isn't related to the thing that you're now adverse to him on, it's really not a problem. I think that only applies to potential clients, not to an active client or former client, not an active client. I'm not completely sure, which is why I call the ethics hotline when these things arise. So when you have issues, when you at least spot an issue, there's a great 800 number to call for New Jersey attorneys, and I forgot her name, but she'll answer your questions on these things. All right, so you need to identify your clients. You need to determine whether a conflict exists, decide whether representation is barred by either criteria of the rule, and evaluate whether one of the exceptions permit despite the conflict. So you can't have concurrent representation when their interests are directly adverse. So this arises when one client asserts a claim against another. You can't even waive this conflict. If two people are fighting with each other, you can't waive the conflict to represent both unless you are a mediator role. But that has to be from the beginning. You're a mediator and you can't side with either party. And they decide they're going to do something more like go to court and not just be mediating this. You can't represent either party. Effective representative of a client who is a party in a lawsuit requires a lawyer to cross-examine another client represented in a different matter. So if you've got to cross-examine their witnesses and then one of their witnesses for the other side is a client, that's a problem. So, example, company A and company B are both current clients. A is involved in litigation against C. So that's not against B, your current client. But B is a material witness to the events that give rise to the lawsuit. To establish your case against C, you have to take a deposition from B. That's a problem. Or company C introduces the testimony of company B at trial. So you must cross-examine company B. You cannot do either, even if your representation of company B is wholly unrelated to the lawsuit between company A, because company B is your current client and you are doing something adverse to company B. All right. Well, they're representing a party, they're with a party who's adverse to your client. All right. Identifying conflicts of interest, top of the next page, 19. Material limitations conflict. Conflict of interest also exists if there's a significant risk to the lawyer's ability to basically carry out the stuff he's supposed to do for the client will be materially limited, as well as the reputation of the client. For example, I don't know if this comes up so much in trademarks, but I'll give you a patent example. If I'm doing a search for, say, a combination toothpaste-toothbrush dispenser, and I'm going to have to limit what I search because some of the things I know about are based on another client who's tried to patent a combination toothbrush-toothpaste dispenser. My recommendation is don't try. There's dozens of them out there. None of them are marketable, and every client who calls me with this great new idea says, how come I don't see any of them out there? It's not because people haven't patented them and not because they haven't tried. There's another reason. People don't want them. So, anyway, so there's issues because now I've got to not tell him stuff that I know about because that would be adverse to my other client who had a slightly different combination toothbrush-toothpaste dispenser. I don't know why they don't want them. I mean, I understand the position that why don't people want these things? It seems like a good idea, but I'm telling you, I've done the patent search. Like every year from now back to 1942 is a different patent for this thing or attempted patent for this thing. Anyway, I can't tell you how many calls I've gotten for that. It's unbelievable. All right, exceptions. Now the exceptions are the things that we want to know most because that's where we actually can do what? Not pay the fees, take in the fees. So the exception where the lawyer is able to provide competent, diligent, and loyal representation of each client affected. Each client gives informed consent confirmed in writing, which I found is harder to get than I thought it would be. And 3, the representation is not prohibited by law or involves assertion of a claim against another client in the same proceeding. In other words, certain conflicts are waivable if both your clients agree. I'm representing one guy for a toothbrush and toothpaste dispenser at the patent office, and another guy comes and he wants to file his application for toothbrush, toothpaste dispenser at the patent office. That is fine because neither one of them is likely to become adversarial ever, and all right, whatever, they might be adversarial, but not in a legal sense. And there really is no problem with me representing both before the patent office. Plus, my representation in this case will be limited before the patent office, not if we start suing each other anyway. All right, duties to former clients. So, absent informed written consent by a client, a lawyer who's formally represented a client is prohibited under professional rules from thereafter representing another person in the same or substantially related matter in which that person's interests are materially adverse to the interests of the former client. So, this is the key. When I was talking about where this guy came and said, when I sent him this letter, he said, I've come to you for consultation. Well, the material adverse is the key. Is that related matter which the person's interests are materially adverse to the interests of the former client. So I represent this guy and possibly seeking a patent application. I'm now sending him a cease and desist on something totally different. That's not materially adverse to the first thing. That you can do. MPC Rule 1.9. So the interest, number 1, the interest of the former client is materially adverse if, note the end, I love ends, because everything has to be required, if it's a prospective client and the lawyer acquired confidential information during the representation of that client. All right, let's just go on to the Rule 1.10, because I already gave an example of that. Imputation of conflicts. When lawyers or associates are in a firm, none of them shall knowingly represent a client when one of them is practicing alone would be prohibited from doing so, unless the prohibition is based on personal interest in the prohibited lawyer and doesn't have a status back of material effect, and so on and so forth. What that means in plain English is if it's a conflict for you to represent someone, it's also a conflict for someone else at your same firm to represent someone. Same firm, same problem. The only exception to that is if the reason it's a conflict for you is because it's your sister-in-law. Someone else at your firm can represent them. You hate your sister-in-law. So you can't represent because you feel it's a conflict, you can't do an adequate job. Someone else at your firm could because that's a personal issue with you. That's your problem, go talk to a therapist and work it out. It's not the problem of the other people at your law firm. When it's a legal problem, when it has to do with confidential information that you have for one party that you can't then serve this other party, neither can your partner. You can't do it either just because only you know it. All right, let's go down to Rule 1.6. A lawyer is generally prohibited from revealing information related to the representation of a client unless the client gives informed consent. The disclosure is implicitly authorized in order to carry out the representation. Break for drink. Or the disclosure is prohibited by one of the various exceptions. Informed consent means you get specific to that case, not a generalized thing they signed at the beginning. Specific to that case in writing that they consent to you doing stuff. In general, clients don't want to sign agreements that say, yeah, I can disclose all the information that you told me. I can tell anyone about what you wanted to patent or what you wanted to trademark. You decided not to. But it is possible if you get them to sign for some reason that they are okay with this. Has anyone ever actually gotten their client to sign such an informed consent thing after they terminate your business with you? That's what I thought. Well, it's nice to know it's theoretically possible. All right, exceptions exist in the general prohibitions of disclosing confidential information. A lawyer may reveal information relating to representation of a client, including information that is, even if it's attorney-client privilege, if it's under applicable law to the extent that any of them are necessary. Now, with the Patent and Trademark Office, there are actually, well, this more pertains to patents again, but there's actually exceptions written right in there of things that you have to disclose. That would be a statutory duty to disclose, which is why, parenthetically, I never sign a confidentiality agreement that a client gives me. Because they'll sign a confidentiality agreement, but I have a duty to disclose stuff to the patent office. So when I have a duty to disclose, I could be violating, I'm in an ethics no man land. I'm in trouble either way. I sign their confidentiality agreement, I'm violating it, but I have to violate it to do what the law says. So therefore, I just don't sign them, and I rely on what the law is. And even if in your practice you think that, hey, I never have to do that, it's okay for me to sign a confidentiality agreement, I mean, in other practices, I mean, it comes up so often, you don't know if the law is going to change, and you're going to have a duty to disclose something, now you're in violation because you're supposed to disclose something. So I just plain old don't sign them. And then I show them, it's in my engagement agreement, I show them my duties of confidentiality, I actually have links on my website to all of the duties at the Patent and Trademark Office, and I tell them, hey, I'm an attorney. You came in here and tell me you just murdered somebody. Unless you're, say, I have the murder weapon and I'm about to shoot someone right outside, or wherever, I can't go and disclose your information. I have an attorney, I have a duty of confidentiality. Here's my license in New Jersey, here's my license in New York, here's my license in the Patent Office. I'm not about to lose my license because you think your combination toothbrush, toothpaste dispenser is the next big thing. I'm just not. It's not worth it. I got a good job. So that's generally the speech I give people and say, I'm a lawyer, I got a duty of confidentiality. That's it. I'm covered by the laws, which are much more strict than a confidentiality agreement. You don't like it? Well, I've never had someone who then walks out and doesn't hire me. Sometimes they want me to print out my engagement agreement, print out where it says all these things, and I sign it, and they sign it and say, here, keep a copy. You know, you just keep it. So sometimes I have that, but beyond that, I mean, that's the extent of confidentiality agreements that I'll do, is basically I'll say, I agree to preserve your confidences in accordance with the statutes and quote which statutes, and that's it. All right, let's go on to MPC Rule 1.4. Attorney's failure to regularly and adequately communicate with his or her client is a major source of client malconduct. I don't know if this is true. Maybe I can get input from other people. But I heard that the place where lawyers, accountants, doctors, whoever gets sued, is not where they did a good or bad job, but where they didn't communicate with the client adequately, where they didn't communicate appropriately and just handle their concerns. For this reason, this is just my personal thing, is client has a problem, they get a rejection to their trademark, for example. This, after all, this is a trademark prosecution class. This happens again more with patents, but they get a rejection to the trademark thing, and they call me up screaming, how can I get this rejection? How can this happen? Blah, 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 blah. I talk to them and talk to them and talk to them. I talk to them because I don't want to get sued. Even if they're right, even if I screwed up, I'm not perfect, nobody is. There's cases where I screwed up, usually you can fix it. Then talking to them and working it out is usually, I find, the way to go, and so far nothing's ever happened. I've had people threaten me. I had a guy the other day, hires me for a trademark, pays me online on my website. I do all the research and this and that. 2 days later, I call him up and said, look, I got everything I needed to do. I'm ready to file. Oh, we decided not to go forward. I want my money back. Like, what are you talking about? I did all the preparation, did everything short of sending you the actual application. Shoots me an email. You don't return my money, I'm reporting you to the ethics committee. So I spelled out for him the amount of time that I spent on the case and why I thought I was entitled to what I was entitled to. Offered him the government feedback and a little bit more to placate him on something he agreed. So, you know, I've had crazy, you know, as fast as he came in for a trademark application and paid me was as fast as he disappeared, wanted his money back after I did the work. So, we have no control over how crazy our clients are, but human psychology goes a long way in just talking to them and dealing with them to avoid any sort of complaints or anything, just to have reasonable communication. So this is the minimum required communication according to the RPC. Promptly inform the clients of decisions and circumstances. If you don't inform the client when they have a trademark office action and the deadline passes or there's a week left because you waited 5 months and 3 weeks, you should be reported. Okay, people make mistakes. Maybe you shouldn't be reported, but you should do everything that you need to do to correct that problem because then it's on you. Personally, I get them an email right away. Within 24 hours, unless I'm on vacation or something, I've got that information forwarded to the client. Email makes life much easier. Reasonably consult with the client about the means by which a client objectives are to be accomplished. Keep the client reasonably informed about the status of the matter. Respond to the client's reasonable request for information as soon as practical. Basically, be a decent human being. Be a decent human being, do your job decently, and you should be okay. This is this rule is just common sense to me. If you have information that you got from the trademark office, forward it to the client. Don't wait 6 months to do it. Client has a question, answer it. Client keeps calling, don't have the secretary keep telling them you're not available for a month because you don't want to deal with them. Yeah, many of them are pains in the rear, but if you don't deal with them, they're going to feel they have no other outlet. So just let them scream at me, put it on speakerphone, wait till they're done screaming, and then tell them why they're wrong. Because that way they've gotten it out, and then they're not going to sue, and they feel like they've had an outlet. Explain matters to the extent reasonably necessary for the client to make informed decisions regarding representation. Personally, you can look at my website, again, patentlawNJ.com. Okay, plug that again, patentlawNJ.com. I've got all the information laid out there. Someone wants to see what's the next step, I send them the trademark timeline, here's all the information. One of the reasons I did it for a couple of reasons. One of them is I was tired of repeating the same information over and over. I still have to because nobody likes to read. The other one is it helps Google search a lot because people come to my website searching for things like trademark timelines. And the third reason is I want the client to know all the information. Let them know everything. I've got a patent guide beginning to end, each step of what it's like to work with me in getting your patent, and what you can expect and what my documents look like with actual cut and paste samples of parts of my documents. Trademarks aren't up to that extent, but they can see all of my work, everything that's to be expected, everything that will happen in the process. And it's good for two reasons. One, because you keep your current clients informed. Two, because I get a lot of new clients that way that just read all the information and say, you gave me all the information I was looking for, and I see you know what you're doing, so I'm going to hire you. So just basically keep them informed, keep all the information there, listen to them when we're on the mouth off so you don't get sued. Moral of the story from our perspective, it all comes down to, well, you should hopefully like what you're doing and enjoy your work and get satisfaction out of doing good work and use the money you make for good purposes, but it comes down to the reason that we work is because, well, some of us would be bored out of our mind if we weren't working, but the other reason is because we need a job, we need to get paid. It comes down to money. So if you want that money, you spend time talking to your clients and you keep them happy. Fees and expenses, Rule 1.5, and then I think we'll jump to we'll do a little more of this. Most professional rules expressly mandate the attorney prepares an engagement letter confirming in writing the nature and scope of representation. Engagement letter should provide a client with reasonable time. Basically, send them, tell them what you're doing and what to expect. I get, for example, the occasional client who then comes time to file a statement of use much later, and they say, "What do you mean I got to pay more money?" So now I've gotten a little smarter on my invoices, my initial invoices that I send them. I spell out clearly. Fee for trademark filing only. For filing in one international class of goods, including government fee and preliminary research only. And it's in my engagement agreement also. Each of these steps is a different fee, a different process where I spell out the steps to clients. Generally, the ones who are complaining don't like to read, which is, I don't know if you guys have found, but most clients, they don't want to read it anyway, but at least if it's in writing, they come back to you and start screaming about it. How can you bill me again? Well, here it is in black and white in writing. And then they might not be happy, but at least you don't get sued. The following non-exclusive factors jump to that, considering determining reasonableness of the fee. Time and labor required, not only difficulty, skill requisite, likelihood, if the apparent to the client accepted a particular employment would preclude other employment by the lawyer. fee customarily charged in locality for the legal services, amount involved, and results obtained. In other words, it's whatever is reasonable amongst your industry. So if every lawyer for this charges $100,000, you can charge $100,000 too, even if it takes you 5 minutes. Obviously, there's no case like that, well, that I know of. I'm sure there's probably one out there somewhere that somebody's done, but whatever is quote-unquote reasonable. Detailed writing. For or after commencing representation, the basis of rating the fees and expenses to be charged to the client. Practice tip. Set forth the scope of representation prior to undertaking any efforts on behalf of a client. Engagement letters and notice mentoring the rules. It's hard to manage a scenario where such an agreement will not be advisable. Lawyers should clearly set out what actions plans to take, and so on and so forth. In my practice, I've got clients that I'll talk to them over the phone. They can send electronic check and credit card payment on my website and get started. And sometimes, I shouldn't mention this on the recording, but sometimes, I just do the work and that's it. They don't necessarily read my engagement agreement, and it doesn't particularly spell it out. So what I try to do is, at least if they do that, is I'll just send them an email saying, this is exactly what I'm doing, this is the scope of my work. Even though I don't say scope of my work and use all these legal words to scare them off and get them to start arguing, I want more and more, I'll just say, okay, this is what I plan to do, X, Y, and Z. That's it. All right. Let's look at Mr. Schedule again. Really confused because the ethics thing is in the wrong section. They have it at the end at 3:30, but it's here in the book. All right. What time is it? How long have we spent on ethics? We're supposed to spend a half hour. All right, we got 3 more minutes on ethics, and then at 3:15 we're going to move on to the next section. So let us jump to the last section, professional misconduct. Misconduct occurs when you're violating or attempting to violate the rules, knowingly assisting or inducing another to do so, or violating the rules through the acts of another. Committing a legal act that reflects adversely on the lawyer's honesty or trustworthiness, engaging in conduct involving dishonesty, fraud, deceit, or misconception, and so on and so forth. Basically, don't lie, cheat, and steal. Lying, cheating, and stealing, or violating a statute, which is usually the statute is directed towards lying, cheating, and stealing, or not representing the client properly, results in problems. Anyone have any good anecdotal stories that they can give on this, of crazy clients that they've had to deal with, to try and lighten up the ethics portion of this? You, sir, smiling in the back. No. Tell me about your craziest client you had to deal with that raised ethics concerns. Where you were right, of course, because you're not going to tell me where you almost lost your license or got suspended. Unless you want to. I'd be happy to hear that story. All right. Fine. Fair enough. Okay, so you can't state or imply an ability to improperly influence government officials or agencies. In other words, don't say, yeah, I know that all the attorneys at the Trademark Office, I can get you a trademark. That is stupid for multiple reasons. 1, you don't. 2, either if you did, they're actually pretty honest over there. And 3, if you were wrong, you will have an unhappy client and an unhappy ethics panel at the same time. Don't knowingly assist a judicial official to do things wrong. Don't bribe people, and so on and so forth. Reporting professional misconduct. In some states, I believe New Jersey is one of them, you are actually required to report misconduct. If you see lawyer misconduct, you are supposed to report it. You are a mandatory reporter. We're also supposed to report all sorts of other stuff. Domestic violence and things of that nature. I'm pretty sure lawyers are mandatory reporters on that. Self-report your own misconduct. Maintain your trust account properly. Don't take money in the trust account when you're not supposed to. That sort of thing. That's called stealing. That's called theft of funds. That's called automatic disbarment in the state of New Jersey. Candor towards the tribunal. For God's sakes, if you got yourself to the tribunal, don't start lying when you're up there. You got yourself that far, don't get yourself further into the mess. You can couch the truth in the best terms possible, in the light most favorable with you, but don't lie. You lie, good luck. If they don't catch you on the lie, good luck. You'll be caught eventually. If you're not caught down here, you'll be caught up there, whatever. It's just not worth it. Alright. Alright, that's enough of our ethics. Any ethics questions, ethics stories, ethics, whatever? Yes?
This sounds sounds simplistic, but is there any time when you, as a trademark attorney, could represent both the licensee and the licensor in filing an application? For instance, if a licensee developed a new mark and the licensor will own it?
Yeah, I think so. That actually happens, again, all the time with patents, because inventions always go to the companies, but your client is really not the inventor who owns the patent rights, but the company who you're assigning rights to. And the same thing could conceivably happen with trademarks. You're really representing both. You really represent, well, in your case, the licensor and licensee. I mean, I guess it depends on your engagement agreement. Because what I would do there is I would want to represent the person paying the bills. Why? Because they're paying the bills. It's pretty obvious. So I would want to represent, say, I think that's a licensee in your case. So, and say, if you tell the other person, you make it clear, I'm representing the licensee, and I'm drafting this agreement, and we just want you to sign this agreement. Fine. They sign it, that's it. You have your client who is licensed and so forth. As long as they are not adversarial, you can represent both parties. It's probably best to get that in writing if they start doing different things and they start negotiating terms. If it's a straight, simple, I'm licensing this totally whatever, that's it, that's simple enough just to do the one-off contract. But if it starts negotiations and back and forth and stuff, then you probably want to get a written waiver. And I think it would be okay to represent both as long as you had a written agreement to them. But the problem with doing that is cost-benefit analysis of what your area of practice is. If they become adversarial and once they're suing the other, you can now represent neither. Whereas if you just represented the person with the bills, the licensee, and you just got a licensor to sign a contract, he could have had his own attorney but didn't, because who cares? They just sign it, whatever. They know everything's going to be okay. Now you can continue to represent the licensee and send cease and desist letters and all sorts of other fun stuff. Does that sound right to you?
Yeah.
You're nodding, so okay.
Yeah, it's just, you could have a situation where, because you have a contractual relationship with the licensor and the licensee, where a dispute could arise even unrelated to that particular trademark. So.
Right. So, I mean, I think it's very fact sensitive. What was your role in relationship with each of them? Who was your client? It wasn't spelled out to them who your client was. Where one is working for another, I think it becomes easier because then it's clear your client is the company, not the individual employee. And even though you're having the employee sign documents, it's because they had a requirement or privity or whatever you want to call it with the company. But here, if you're talking about two totally separate entities, licensor and licensee, that really one has no privity with the other, I think that might be a different case where it is more of an issue. Okay. All right. Yes.
I have a question about this, the ethics and trademark registration process. On page 17, the part about recommendation of search.
Yeah.
When you're discussing, is that something you discuss with the client? You said it might differ depending on the type of client. You would.
I refuse to do trademark applications without a search. I should say refuse. There's limited circumstances where I know already, where like I know the client, I know the market because we've done other stuff together or whatever, but short of that, I refuse to do a trademark right application without at least a preliminary search.
And then does this mean you should really advise the client on the scope of search that you're planning to do and what it is you're not going to do?
Yeah.
You maybe give them the option, we could do this more expensive thorough search.
Yeah, I do.
Or we could do...
Right, I do. I mean, truth be told, a lot of times I don't mention the full clearance search because people call me up. If the first question when they call you up is how much is a trademark application, chances are they've called 50 lawyers already and it's not going to matter what you say. But, so I tell them the basic package and I tell them why my basic package is better than everybody else's. And what it includes, and this is the price for the whole service altogether in one nice fee. I mean, that's more business stuff than anything else. But, I make it clear it's a preliminary search. I make it clear in my invoice when I send it to them. I make it clear in the results. This is a preliminary search. And if they ask or want to know more, I show them on my website where I've got an article on the difference between preliminary and full clearance, and all the information is there for them to see. Personally, I just find it easy to put everything on my website and refer them to a URL, all the information, to make sure I didn't leave anything out. I should have told them. But I tell them that it's preliminary search, and I tell them that they should do full clearance searches. They really should, but it's a huge difference in price. It's a fairly straightforward process to file a trademark application, and for that reason, the price differential between filing and doing a full and proper clearance search oftentimes doesn't make sense to a client. Like, why should I spend more than double, on the total process? So, it is what it is, but really, you should. That is what you should do. The filing is a small part of it. The diligence is really, well, the filing has to be right, but the diligence is really more important. Clients tend not to see it that way, though, because clients, it means how much to pay. All right, let's move on to the next section where they have a nice picture of the Trademark Office website. And they have, this is where you go to the online filing. You file online, EFS website depends. Up top, on the right side, they've got the different things. Test, TESS, we're looking on the right page there. Test is where you do the searching. You can do the quick and dirty searches for other trademarks. T's is where you file trademark applications. TSDR is their new thing, where you can look at the entire trademark file. Trademarks are public. Because trademarks are public and all the data is public, you get a lot of scams. Scam artists send things. I've seen the same one 25 times to clients. There's two things you see. One is requesting money for the claiming to be something which is, as well, for lack of a better term, confusingly similar looking to the trademark office. And they try and say you owe money, or trademark monitoring service, or watching services, or generally scams, or at best unsolicited advertisements. The other one is from China. They say, oh, your trademark, if someone's trying to register your trademark with a .cn name, but we saw that you have a trademark registration, so we're going to give you 30 days to register it first, just pay us money. That's a scam. The first time I believed it and billed my client a ton of money researching this and looking into it, so it wasn't that bad for me. It was honest, serious research. But after about the 15th time you've seen it, you're like, come on. So, anyway. Assignments, to transfer ownership. There is no online form for transferring ownership. You have to write the form properly with all the legal stuff, transferring goodwill or whatever. You can also record licenses. I'm sure you do, to record licenses for trademarks. They are same thing like recording real property. Recordation gives you rights ahead of a non-recorded person, or even if the person is before you were non-recorded, so you want to be recording. TTAB is Trademark Trials and Appeals Board, where we go and fight it out with others. That's where you file and also look up data related to trademark oppositions and cancellations. And also appeals, if you actually appeal a trademark. Dashboard is where they give you lots of fun statistics under the latest what's his name? John Dudez was the last guy. I just forgot the guy's name. Capos. Capos is the current head of the trademark office. He added this dashboard thing. You can see all the statistics, how long is it taking, how many cases did they reject, dispense with, and so forth. So if you go on to the next page, where it says select the search option, this is actually probably one of the more useful portions of this talk, because this actually shows you how to do the work. Like law school, where they never actually taught you how to be a lawyer and do anything that you actually do today. This actually shows you something of the practice and what you do. So there's the basic search, that top option. This is after you select test. You can just type in name. It's a very simple search. Hey, there's the patent office calling me now. 571272 is always the patent office. So a basic word search. You can actually add in there more complex things you're doing to limit by class and so forth, and then there's more complex ones. And then, so they have their law review CLE trademark there that they've trademarked to show you the kind of information you get off tests. So their goods and services, you can see they're in class 9. They trademarked it for audio recordings featuring legal education, because that has to do with, again, if you remember, class 9 is the computer service mark stuff. Now, why they don't also have a trademark for live lectures, I don't know. Maybe they haven't done that yet, but technically this live lecture is not covered by that trademark. However, if someone else gave a live lecture called Law Review CLE, then that would be confusingly similar to the trademark, even though they're only in class 9, because that's pretty close. Now, where it gets iffy is suppose they call themselves Review Law, and they give only lectures and nothing online. Is that trademark infringement? you can make a pretty good case for it, but if their trademark was also in class 41 for educational services, they'd have a much better case for stopping a guy that calls himself Review Law and does the services of lectures. So you can see that they first used it. Wow, phone is going nuts today. No secretary. Wow. All right. First use is 2010. It kind of tells you how long they've been around. Serial number, filing date. Filing basis 1A means they filed it as currently in use. And you can see they filed it June 7th, 2011. By the time they got through everything, it was issued May 8th, 2012. So it took 11 months, which is about right. Supplemental register, that's interesting. Supplemental register meaning that is a descriptive term, meaning they only have common law rights. Law Review CLE might not have me here again if I critique their trademark to death, but they only have common law rights because Law Review CLE just describes what they're doing. They're giving CLE classes for review of the law. So after 5 years of use, they will refile and get a second registration on the primary register. I know of a good trademark attorney they can hire to do that for them. Okay. Next page, trademark process. So, I'm not going to go through those initial steps because steps 1 through 7, because I covered it earlier, but just to refresh your recollection, as they say in criminal law. First, you need to figure out that it's a trademark. If a person comes to you, I get this sometimes you get from unsophisticated clients, I got this, I want to patent it. And then you go and look at it and say, or you talk to them, what do you want to patent? My logo. Oh. Okay, you want a trademark? Yeah, that's right, I want a patent. No, you want a trademark. Oh, okay, yeah, patent. Okay, fine, let's go forward. So, you get their logo from them, you tell them the price, and they're like, wow, really? The other guy told me $5,500 for a patent. You're telling me under $1,000 for it? Yeah. So anyway, they go forward, you file your trademark. Determine whether you should hire an attorney. The answer is yes, they should hire an attorney unless they know what they're doing. Trademarks, you can probably fake it, but if they screw up, they screw up bad. I've seen cases like that I just could not fix after the way they filed it. They filed it in one class where they should have put it in another class to get around an opposer or get around the potential rejection, or listed their goods a little different, because some of it's partially an art. You know, how do you describe your goods? Do you describe it as computer software download, or do you describe it as a website featuring artists, or whatever it is? There's different ways to try and have more likely that you can get through than not. Or somebody files a mark for Cadillac Business Consulting with a picture of a Cadillac car. GM never had to oppose that because the trademark office was not letting that through. They call me up and say, okay, you know, can you fix this up? What price can you give me? No. You have a picture of a Cadillac car. It's not going anywhere. So what they could have done, had they hired an attorney to begin with, would say Cadillac Consulting, Cadillac Business Consulting, file a word mark, file a different logo, for God's sakes. And they might very well, and they probably could have gotten that through, because Cadillac is actually a word in the English language. GM does not have a monopoly on the word Cadillac. A lot of these companies think they have a monopoly on these words. Abercrombie & Fitch, for example, thinks it has a monopoly on anyone putting a bird on their clothing, or was an owl on their clothing. And then I went in my response, showed them 10 trademarks that preceded them as if they didn't know, that all had owls on their clothing, and said, unless they have your specific owl, you have no case. And they harassed a few more times till they went away. One of my favorites. Well, I'm on the topic of my favorite companies. Pepsi. I now drink all. Wait, is this a Pepsi product? Oh, I guess I still drink Pepsi products. And from their attorney, they told me I'm in violation. I did work to see if there was a patent claim on one of my clients. A client currently has a lawsuit against them, and they told me I got a letter. You personally are in violation of our confidentiality agreement. This is there was an order signed by the judge that the discovery is confidential. That you need to destroy all the material. I basically told them, go take a hike and forward your letter to the judge. I never signed any confidential agreement. I never knew any such thing existed. And when you disclose it to an attorney, it's attorney-client privilege. He responded at midnight on Saturday night from his iPhones filled with spelling mistakes. This is an attorney for Pepsi. Anyway, I'm sorry, I just needed to get that story in somewhere, and I couldn't find a better place to get it in. Yes, sir.
I just wanted to mention.
You dealt with him.
No. This goes back to your the ethics discussion about RPC 1.7 in New Jersey. Just of course, this doesn't apply to anybody else in the room, I guess. But if you happen to represent a public entity at the same time you're representing a private entity or two public entities, and that you have that conflict of interest situation, you can't get consent because public entities are not permitted to consent in that situation.
Really? Okay, but you can't get consent because they're not allowed to give it.
That's right.
Okay.
And it's in the New Jersey version of the rule.
I mean, how many people give consent? It's probably because they're afraid a government official is going to go and do that because they work for the government and really don't care that much.
Maybe.
But private clients, I think I've tried it twice. Well, once wasn't, I don't think anything went forward. But I could not get consent from my clients. I had two different clients that wanted to do something related to whatever, mass transit thing in Manhattan. I'm not going to give more detail than that. And I could not get consent. I was like, all right, whatever. You know, I had to not take the second client because of that. All right. You can look at trademark-timeline on my website to see all of this in a nice, pretty graphic. USPTO reviews the application once we figure out how we're filing, intent to use, so forth, actual use. They review it. Once they review it, and you go back and forth with them, you get they're going back and forth. It's called an office action. You have to respond to it. They publish it for opposition. Once it's published for opposition, if nobody opposes it, you get a registration certificate, or, as they write in step 13, a notice of allowance. And if there's a notice of allowance, because you file it at an intent to use basis, not a currently in use basis, you now have to file a statement of use showing that it's used. And then that would be step 14. We're already up to step 15. I'm going fast over this because I already covered this earlier. If you don't file it, the statement of use or accession request, or if you don't respond to an office action timely, your mark is abandoned. Within 2 months of abandonment, you have the right to revive it for a fee. It's actually only $100. It's really not that high. Interestingly enough, the trademark office will only tell you, they will never tell you you have a deadline coming up. They will tell you, they will send you a postcard in the mail if it's abandoned. And I'm sure that if they sent the postcard to remind you that your deadline was in a month, as opposed to it's been abandoned and you now have 2-month deadlines, they would take in much less fees. That postcard, whatever, I don't know, postcards cost to mail these days. It used to be 19 cents last I mailed anything. What are postcards today? Nobody knows. How many people still mail letters? Do you mail letters to clients or just email them? Anyone mail letters to clients? That's awesome. Anyway, whatever it costs them, they only send it out to you after they can get the $100 fee. Which, okay, granted, if I was running the trademark office, I'd do the same thing. I don't blame them for doing that, but that's how the system is. Out of curiosity, the last place I spoke was to SCORE. They give their retired business people that give free advice, and I was using this as using my phone, which just calls people. It really doesn't do much more than that. I'm a patent attorney. I don't have a phone that has like internet or anything. It just dials. And I was using this as an example to show, talk about design utility patents. And I asked them, how many people here use a smartphone? There's about 30 people. 2 raised their hand. I'm just curious, in this crowd, how many people here have a phone that you can get your email and internet on? Younger crowd. Mine just dials. I can call people with it. If I had my email here, I would not be able to concentrate on talking to you. I'm already looking at it, just see the phone number of the people who called, which I shouldn't be doing. But anyway, all right. This is just to lighten up, make it more interesting, and keep my statistics good from talk to talk. All right. USPTO reviews the statement of use. Once they review it, then you get a registration certificate, and then monitoring. You can monitor the TSDR that we talked about before. You go to the trademark website, you can monitor it, you can see all the documents, you can see what's going on, you can see their internal documents they don't mail out, all those fun things. And then step 19, protecting your rights. I'm going to read this because this is important. You are responsible for enforcing your rights if you receive a registration, because the USPTO does not police the use of marks. Well, USPTO attempts to ensure that no other party receives a federal registration for an identical or similar mark, meaning anything which has a likelihood of confusion, for or as applied to related goods services. The owner of a registration is responsible for bringing any legal action to stop a party from using an infringing mark. It's your duty to figure out someone's infringing and file a, that would be filing a case in court. You would file in actual Article 3? Yeah. Article 3 court, your typical court where you have a judge and adversary for trademark infringement. You might start with cease and desist letters and so forth. If a cease and desist letter says, if we don't hear back from you, I will advise my client to take all legal action necessary to him. I found the translation is, client's only paid me for this letter, who knows if he's going to go forward, probably not. If you don't respond within 30 days, here's a copy I plan to file in this court. Unless I hear from you by this time, that's probably they've paid a $10,000, $15,000 retainer. So I find they're pretty good indicators of the seriousness of the letter. The kind of cease and desist letters are kind of encoded so the other lawyer can understand what's the nature of the case and what the other attorney thinks of it. At least that I found you can just figure out how they're encoded to figure out the seriousness of the case. All right. Now we're going to get to, are there any questions since I breezed through that section on the registration process? Yes?
Is the official gazette online?
Yes. It used to be published back in the day, physically published, probably still is somewhere, in the Library of Congress or who knows where. You can probably get a physical copy, I don't even know. But yes, the physical gazette is online. It's a couple 100-page PDF that comes out every Tuesday. It's, I'm sure back in the day.
USPTO website?
Yeah, somewhere. I don't know where. The easiest thing is to go to Google and type in Trademark Official Gazette or USPTO Official Trademark Gazette or something like that. Comes up quicker than going through their website to look for it. It is online. I looked through it once because it's kind of like interesting to look through and you see all the marks, but it's not practical for anybody to go through that once we can look through it, which is why there's monitoring services which let you know, which are basically, they're not looking through either now. I mean, that's how they originally started. There were companies that looked through, they cross-reference to every one of their clients' marks was doing the monitoring service to see, but today it's all electronic. They just pull out of the database. I assume that there's people that are really looking at them, but today it's probably mostly like SoundX stuff. They've just entered all the possible variations of names and have algorithms to pull them out and automatically send them to clients. There's also monitoring services that will remind you of long-term deadlines, because in trademarks, your next deadline is 5 and 6 years later. I maintain a spreadsheet and an online calendar for that, which is a pain in the rear to do, but you can just hire someone that basically all they do is they send you the reminder in 5 years, and then again between the 9th and 10th year. And then if you're between the 9th and 10th year, you need to remind them again in 10 years. You don't remind them between year 19 and 20 because you haven't dealt with this client in 10 years. That's malpractice. So you need to maintain proper calendars and remind them and make sure to remind them of each deadline. Some attorneys will put it on the client. Some of them will say, docket this yourself, I'm not doing it. Some of them will even remove themselves as attorney of record. I don't think that's good service. I don't even know, what would happen. I mean, it doesn't happen often that they really raise a problem, that they forget, you forget, and they go and raise an ethics issue because you didn't tell them. Because people just tend not to stay with brand names that long. But, it's something that is very important and for obvious reasons could happen, that you don't remind a person of a deadline when you need to. So you need to docket those deadlines and remind them, and hey, it's extra money because then you're getting the fees for the docketing and the reminding or whatever you're making on top of paying the docketing service, and the fee for then filing the statement and the continued contact with the client. Now 5 and 6 years later, you call your client and say, hey, we got to do this. And they say, I've been meaning to talk to you. There's this other work that I wanted to do. And, you make contact there for the business that way too. So anyway, next page. Nice Agreement 10th edition. General remarks, class A explanations. So this is the international classification system. Basically, classes 1 through, 30-something is 29 maybe? No. no, 1 through 35. 1 through 35 is goods. 36, I believe, through 45 is services. So goods are tangible products. Can even be computer software. It could be web stuff that's going on websites. It's also International Class 9. Services, which websites that overlap directly between 9 and 41 or 42 usually, because it's a downloadable thing from a website, but also websites are almost always some sort of service. For example, you're selling goods online, that's really a retail and what you file is retail and online services or whatever it is, retail and mail order, online and mail order services in class 42 typically. So they're giving some crazy examples here. I don't find this comes up in practice so often, but a finished product is in principle classified according to the function or purpose. It is not mentioned in any class heading. It's classed by analogy with other similar things. So you try and find the best class to file it in. Usually you can get it from, there's a manual, you can search online, or the printout is like this, the manual of goods. You find the closest goods possible. The client's usually happy with it anyway. Or you find where it fits. You find what class description fits, what goods in that class are most analogous. That's where you file it. Raw materials got their own classes. They're classified according to the material which they consist. So paper products, paper goods, I think are class 16. So if you have a paper mat, it's one thing. If you have a fabric mat, it's class 18, I believe, or 20. I don't remember exactly. And so forth. It's just basically you find the most appropriate class for it. Services, so same thing. You look through what makes the most sense. Rental services, the good example is class 38. Leasing services as analogous to rental, and you can look at class 38, you'll find leasing all over the place in 38. But then hire, lease, purchase, financing is a finance service is 36. So if you're representing a guy who does leasing and financing of cars, you're potentially in 2 classes. So what do? You tell him, and usually he doesn't want to pay for 2 classes. He wants the minimal fee. So you tell him, well, okay, what's your primary business? What really covers more? We'll do it in the leasing class. And financing, if someone's financing under your name, it's also still likelihood of confusion. You want to save yourself the money, you probably can, you're fine. It's scarier, it's better to have in more classes, but that's offset by cost. Alright, services that are primary advice, information, consultation, are the same class as the services that correspond to the subject matter. So, for example, it's just easy to go through these examples. Transportation consultancy, 39, has to do with transportation. Business management consultancy, 35. Financial consultancy, up above, we saw financing was 36, and financial consulting is 36. Beauty consultancy is the same thing as like retail beauty services. There's things that people do to beautify themselves in services. They go to those things where the women get their hair done and legs waxed. Those are all in class 44. Should have a more formal name than that, but the rendering of advice, information, consulting by electronic means, telephone, computer doesn't affect classification, kind of. If it's by computer, you can oftentimes get it in class 9 in addition to one of these. You need to figure out what's better for your client. Alright. This is an entire list of the classes. I'm obviously not going to go through the classes, but that's just for your review. This is also on my website where I've got a quick overview of the classes. patentlawNJ.com/trademark-international classes, I believe, or something like that. I've got a quick overview of these classes where you can look up quickly where something is put in electronically. All right, what time do we have? We have 15:44. That would be 3:44. All right. Now, here is the online filing form. This is actually really useful to go through. This is the kind of thing that do not show you in law school. This is on page 53. So, on page 53, this is an actual screenshot from the Trademark Office website. So on there, typically what you would be doing, or always what you'd be doing, when you start the process is number 1, initial application form. The other options there, response form, when you're responding to an office action, you can do it electronically. And if it's something simple, like in the case we had before of a colon or not colon, you go right on there, you would click response form, and you would just you check the appropriate box. It gives you questions. Do you need to do this? Do you need to do that? Do you need to do that? Amend the mark would be question 1. Hit yes to 1. Provide a disclaimer would be checkbox number 2. So you would just do checkbox number 1 in the colon case. And what you would do is then you would hit submit, whatever. It takes you to the appropriate form. You enter the new version of the mark with the colon, submit, next, a couple times, sign it, submit, and that's it. It's that simple. In the case, can I talk about your case in more detail, what you told me? Or? Okay. So in her case, she said that the place that they were using, in order to add this colon, was charging $175 for this.
It was removing.
Removing a colon, same difference.
Yeah.
It's for a trademark claim, the same thing. Colons, S's, things like that don't matter in a trademark application. Occasionally they might say, no, you're materially changing the mark, we won't allow it. But for a colon, I can't see them doing that. If it's too far, let's say it's materially changed, you can't. You can't change it from Blistex to Bastex or whatever. But you can remove it out of colon, remove it out of an S, remove it out of space, things like that. They usually don't give you trouble over. I had one where I had dots in the application, but then in the specimen, it was a graphic where he had dots, his labels he's putting in the shoes. He's selling shoes in his store, like Forever 21 or one of those, Lucky 21. Also had a opposition on that I won, but he had Lucky 21 and he had dots above it, and then the specimen he didn't. They didn't let me remove the dots from it, and we had to refile without the dots. But on a word mark, that doesn't happen so much. They said that's a material change. We could have fought it, but whatever, client didn't. I think we might have won that, but again, client didn't fight it. In any case, yes?
I have a question on that sort of thing. What about if you have a word that has different sort of like foreign accents in another language? How do you...
Never had it happen, but I would imagine it's not a problem, because what do Americans know of foreign accents anyway?
So you'd file the word mark. Obviously, it wouldn't let you use that other language's accent in the word mark, but you may want it in your symbol.
Yeah, so I think that would be what happens. Okay, practically speaking, what you would do is would you do this? I need to think about it. I never had the case come up. I need to give it some thought. But I guess what you would do, first of all, I would try entering the character. Copy and paste goes a long way. I just try and copy and paste it with the umlaut or whatever, and I think that would be okay. I don't know for certain. I need to look it up in the manual of trademark procedure whether you can submit a standard word mark with an accent mark. I'm really not sure the answer to that. But option 2 is you file it as a logo mark. You file it as a logo mark and you just submit the thing with the umlaut on it or whatever. That there'd be absolutely no problem with. And you could state on it either in a special statement or whatever. There's no claim to a specific design function, whatever. It's just to the word. And probably be fine. Again, I need to do research, but you can do it in one of 2 ways. Right, so point being, things like this don't necessarily take a long time to do if you're doing it electronically. They make it fairly straightforward and simple, but you kind of have to know what you're doing. You have to know, and some of it just comes with experience or asking a person, can I do this or not? You can also just call the examiner. For something like that, examiners want to get this stuff off the docket as fast as they can. The more cases they have a certain amount of cases they have to dispose with, you call the examiner. They generally, I found they're very friendly, and I would say to them, hey, I want to remove this colon. Their phone number is at the end of the office action. Phone number and email address. You can also email them in most cases and say, yeah, okay, can you just remove the colon by examiner's amendment? And they'll generally do it, and then they'll allow the case to proceed, if that's it, if that's the only issue. Many times they'll just call you up and say, this is fine, but your statement of use doesn't match, it has a colon. What do you want to do? You want me to remove or add the colon or whatever it is to the written form of the smart? And you just say yes, whatever. So it's usually for something like that, it's fairly simple. All right, intent to use forms, number 3. That's where you submit your statement of use that we talked about. 4, post-approval publication, post-notice allowance amendment forms. That's remove out the colon once it's you have the statement of use thing. 5, correspondence attorney domestic representative forms. That's where you file your power of attorney. 6, petition forms. That's where you petition, say, letter of protest or revive your application that's been abandoned. Miscellaneous forms are forms which in my practice, I don't think I've ever had to use one in there. They're really obscure forms. 8, registration, maintenance, renewal, correction forms. This is where you file your section 8 and 15 affidavits and later your section 8 and 9 affidavit to show that the mark is still in use. It's basically check the boxes, pay a fee, say your attester still using the goods, submit a new specimen, that's it. Assignment forms, this is where you upload your own form that you've drafted, not their form. You upload your assignment form to assign rights to another. Trademark, trials, and appeal board forms. Self-explanatory. Madrid protocol forms is you can actually, through the U.S. Trademark Office website, you can file foreign applications under the Madrid protocol. Madrid protocol is basically, it's an agreement amongst a ton of countries, not including Canada and India, notable exceptions, where you can file a trademark in the United States. You can then have it filed internationally simply by paying the Madrid protocol fees and each country's individual fees. If there's a problem, though, and you get a rejection or some sort of issue, you as a U.S. attorney does not have the right to prosecute the application further in these countries. So if there's a problem, you need to retain local counsel in those countries. So I don't do it so much with trademarks. I don't have that much international trademark business, but I do it with patents. And I've got attorney in India, Canada, Israel, European Patent Office, Europe, UK. Also I've dealt with Russia, South Africa, Turkey, Pakistan. I don't have an attorney there. I have a client there, believe it or not. And whatever, Japan, China, Korea. So all these, Australia, all these countries I've dealt with where you hire a local counsel to continue the work there. So that's what you would do if you got a rejection in one of those countries. You get a rejection in Korea, you hire a Korean attorney, which I had to do. They fix up the mark, they do whatever needs to be done, they argue it, you relay that back to the client, bill, forward fees around, get paid for forwarding fees around. That's the best. Another attorney's doing the work and you're just forwarding fees around and taking money. So anyway, now we're going to go into it a little more. 55, this is an actual thing. We can go right on to, you would choose T's plus, which is you choose from the things that are there. T's form is just you enter the goods and services on your own. And then jump down to 57. Question number 1. Attorney filing this application, you would answer yes. If you're a paralegal working under an attorney, I think you would still answer yes, but the attorney has to sign off on it. The attorney has to do the actual submission.
Right.
Because what would happen is you get to a place on these trademark forms where it's emailed. I imagine a paralegal could fill out the whole form, and as an attorney, this is also relevant because you could have your paralegals. You have someone who's much better at computer stuff than you are. You can have your paralegal, your intern from law school, your free labor, fill out all of this stuff, and they say, "Yeah, I'm learning this," and have it emailed to you. You then review the application in nice printed format to read the whole thing, make sure it's okay, and then you as the attorney are the one who hits the submit button. So then you fill in the information on the first screen, then the owner of the mark, entity type, individual company, the address, phone number, and so forth. So they're showing you then, I'm up to page 61, they show you how they fill it in. I do not fill in phone numbers and fax numbers of clients. That is only going to get them spam. I don't fill in their email address either. I fill in my email address, but I don't fill in my client's email address for 2 reasons. I don't want people that want to send them letters about their trademark. I don't want it going directly to the client. I want it going to me because it's supposed to go to the attorney. It's not supposed to go to them anyway. There's no reason why anyone needs an email address over there. They're supposed to be writing the attorney. You're supposed to be dealing with it on behalf of them. And they don't need to be getting spam from them, letters from China telling them the domain name has been registered when it's not. That type of thing. Trademarks, then I'm up to page 63. This is where you enter the mark itself. So they enter Law Review CLE as a standard character mark. See up above, there's a radio button. You could instead choose special form or a sound mark. Additional statements on page 64. Most common one they put first is a disclaimer. Unavailable is calling me. They put a disclaimer. So, for example, if I file pre-contract ink, I put a disclaimer on the ink. I put Google.com, I put a disclaimer on the .com. You have no right to claim .com any better than anybody else, so the disclaimer is exclusive from the mark as shown. You're claiming the rights in your mark, is what I explained to clients, make it more palatable for them when they get a rejection saying they need a disclaimer, is say, look, you still have it, your mark's still intact, you're just saying if someone uses that word outside of the mark, you have no claim against them. Prior registrations, translations, these are all things that are required. Meaning significance of it, so they give this sometimes because we want to know, is your mark descriptive, suggestive, generic, what is it? So if I have the name FUBU, and FUBU means for us, by us, they might say, I want to know what it means, and they'll say, oh, for us, by us is descriptive of your services. If not, what if it were, then they might give a different rejection. Oh, I had a good case. I can't remember this. Wearables. Wearables is one of my clients, a good guy. He sells these cardboard products that you take out of the box, you color them, you paint them, and then the child builds them and they actually wear them, and they run around looking like a plane or looking like a bulldozer. They're really cool, actually. I got free samples for my kids. Love free samples from clients. Anyway, I actually had the examiner said, I want to know the significance of the word wearables. So I explained it and made a preemptive argument for why it was not descriptive. Even though he's wearing the product, I made a preemptive argument that one wouldn't know from wearables that it's a thing that you construct and put on you. It could be anything. It could be talking about wearable marker because it washes off or who knows what. It wouldn't necessarily know it's a cardboard construction thing. So that's the type of thing that you have to deal with what's the significance. 2F based on use. What happens here is if you have a descriptive mark, or in the example I gave in the very beginning, my lady with pocketbooks, she has, she wants to protect, she's got AG repeating all of her pocketbooks. So we had to get that on the supplemental register because it's not 5 years of use. Once she uses it for 5 years, we would file it on a 2F basis, saying that because she's been using it for 5 years, it's now distinctive, and now this thing that before, which was descriptive or only allowable on the supplemental register, is now allowed on the primary register because it's become distinctive. Now, Coach Bags, when they file them, they check this box right away and say it's distinctive for their patterns on their bags. Why? Because it's accompanied with a statement, an argument, or whatever, saying that we spent $30 million promoting this bag. It's distinctive. And so the trademark office says, spent $30 million, fine, we'll call it distinctive. Its trademark office is very commercial friendly, they're very business friendly. The laws are easy to deal with and stuff like that. It's United States, it's set up very well for commerce. Try and do this stuff in other countries, it's who do you know and who do you bribe. So for that, I'm very thankful to be in the United States. All right, and so forth. Those are different ways of establishing 2F, based on use, prior registration, evidence, and so forth. Name, portrait, significance of individuals. One of my clients is Beau Brummel. He's a guy that lived in the 1800s. This is my oldest active trademark because I took this over. It was first registered in 1910 or something, and he's currently my client, and I maintain his trademarks. So we have to say, Beau Brummel is a dead guy or he's a live guy who consents to registration of the mark. You put someone's name, you need their consent. I get crazy cases every now and then. You get something like jewelry designer, husband and wife are divorced, and the husband wants to go and register his wife's name because then he wants to protect it. They never registered. He wants control over it. He can't do that. He doesn't have her consent. You know, crazy stuff like that people do.
The activity code for this session is 599809.
I had one case where I went so far as I prepared the whole application and stuff, and I just realized this is fraud. This is like you're trying to get the name of somebody else. They give me up and down. They'll get consent this way, that way, and stuff, and just file it anyway. Just sign this. Oh, I'll just sign the statement. That was the person I gave the government fee back to, and not their, not the fees that I did on preparing the whole application, because in my mind it was clearly fraud. It's just not worth getting involved in. So forth. All right. Concurrent use is if there's someone else who has a mark that I think concurrent. I'm not sure concurrent use. Maybe it's a different thing. Yeah, no, this is. If there's someone else who has a mark, but they're using a different geographic area and they consent, they're Arby's in California, they consent to you being Arby's in New Jersey, even though you're two totally separate companies. If you have a consent statement, you can file it and use it regardless. It's often a way to, people aren't usually agreeable to it, but it is a practical way for people who are sane and rational, who both have rights to using a mark, but are not exactly the same, to settle their dispute. Usually the one who's using it earlier first and the one who registers earlier first wins, but you can settle the dispute this way. I can just consent. I had this case, last time I did a consent agreement was, I can't remember the name of the mark. It was the same client that did FUC Consulting. I can't remember the mark. It was like Black Bodies or something for clothing towards whatever, the African American community, and someone else had Black Bodies or something, and then they just consented to use in different geographical regions or something like that. All right, next page, 66. That's where you add the goods and services. This is and now jumping ahead to 68. This is the T's plus form. If I type in legal education, the search is actually pretty lousy the way it works, because it gives you anything with the word legal and anything with the word education. It does it, and it sorts them by class, not by relevance. This is how the government develops a search engine, as opposed to how Google develops a search engine. So anyway, you got to go through and find the appropriate thing. Here you can see they checked off audio recordings featuring. You see those brackets there? You can specify whatever it is. So it's still pretty free form in a lot of these things for specifying things. Now you see also came up is stuff came up not only in 9 but 41, production of audio recording. So they probably could get in that one, but 9 is the more appropriate one for them here. And so then the next page, I can't see a page number here, you see that they've added audio recordings featuring legal education. Filing basis 1A is currently in use, 1B would be intent to use, and it is currently 16:02, which is 4 o'clock. Do we have 4:15 or 4:30? 4:30? Okay. Then, if it's currently in use, then on page 70, you have to attach a specimen. You have to show it being used. So you click Attach Remove Specimen. Here you see they've already had one file attached. You submit a JPEG or PDF of your picture. If you don't understand what a JPEG or PDF is, hire a paralegal who does and have them do this for you. Graphics editing is actually very useful for, well, patents too, but for trademarks, to be able to manipulate the graphics for the logo, pull it out of people's websites, because now a client comes to me and say, oh, you have it on the phone even. You have a website, show me a website, I'll go there. And then all I need to know from them, their name, their address, sometimes I get that off their website. The only thing I know them is state of incorporation of their company, full company's legal name, first date of use. Sometimes to figure out the first date of use, you do a who is search. A who is search, for those of you who aren't familiar, is searching the domain name registration database. When did they register the domain? Yes?
So would that be the first day of use, even though they weren't?
Excellent question. Usually not. It depends. Usually people register domains before they started using it, so it gives you a general idea. The way you file the application is if you look there, date of first use of mark in commerce, by the applicant or applicant's remaining company, licensee, or predecessor in interest, at least as early as. So if they registered the domain January 1st, 2007, they say, well, okay, roughly how long was it from when you registered your domain until your website was up in public? They say, I don't know, about a month. Okay, so February 1st, good. Let's put February 15th just to be on the safe side. So I put February 15th, 2007 is at least as early as February 15th, 2007. So if you go too late, not so much of a problem. It doesn't look as good. You're not using it as long. It's less scary to people. If you go too early, it's fraud. So I err on the late side. If it's fraud, the trademark application is useless. It's kind of like Price is Right. You bid over, you've got nothing. You bid under, okay, you got a bid in. So you've got your trademark application in there. Yes?
So what if someone, going back to that same consulting situation, if that person never set up a website?
They don't have to. I was just using one example.
Okay, that's what I wanted to know.
That's just an example.
In this day and age of electronic commerce.
Right. I mean, they're a standalone store. They're I'm looking at a website. Who doesn't have a website today? I don't know. Whatever it is. they're whatever it is. They're a standalone store. I've got one. Edible Creations Yogurt. They don't have a website that I know of. Maybe they do. They have a standalone store in Lodi, New Jersey. So what I submit there is a specimen, picture of their storefront. That's it. Picture of a storefront or a picture of their menu or something showing how they use the logo in connection with the commerce. So then you just do it as least as early as, and you try and get a good estimate from them, and you try and make sure it's reasonably accurate and so on and so forth.
What if there's a domain name that's up there and talks about a product, but the website's not really selling the product yet?
All right, it's a very different topic, but I'll talk about that one because this comes up very often. Domain name registrations and trademark registrations are two entirely different systems. They sometimes come to conflict. They sometimes help work together. Typically, a person wants to get the domain name exactly what their trademark is.com, which isn't always possible. It could be a problem. One of my clients is VidBid. He's trying to get vidbid.com. It's owned by somebody else. Right now he's, vid-bid or something. But there's two different things. If the person is selling, so supposing they have a video auction site on vidbid.com, his registration of VidBid trademark would be afterwards in time. That's a problem. He really wouldn't be able to do that because that would be, quote, common law trademark infringement, even without the vidbid.com having a trademark registration. Now, on the other hand, what's really happened, vidbid.com is just a shell of a site. There's nothing there. Probably as many as GoDaddy's pictures of the same girl with a backpack trying to sell it. If you've seen that picture. I haven't seen that one lately. Maybe they stopped using it. But anyway, and he is VidBid, and he starts doing video auctions. If they put a video auction on their website, they are now infringing upon his trademark. The domain name is completely separate from trademark registration. The only place where, well, I should say only place, the common place where it overlaps is domain name squatting. I can't register a domain name, Microsoft.com, and expect Microsoft to pay me $1 million for it. No, they will just file with the Arbitration Association, which is how domain name works. I do that too. I do domain name disputes. It's very hard to get a domain from somebody. The ICANN, who deals with this, the International something, deals with domain names. They don't want to deal with disputes. They want to just maintain the database, collect the fees for maintaining the database and the domain name registration system. So the ICANN policy that everyone has to agree to, whether they know it or not, when they register a domain name, is they are agreeing to the terms that say that a domain name will be given up in one of three if three cases are met. One, this is not really in here, but it's really good to know. One, there is a valid trademark for the name. If there is no trademark registration, they haven't the chance they failed the first prong. Two, there's a legitimate business interest in the name. And three, there's no legitimate business interest in the name. And three, they have registered the domain in bad faith. Bad faith, as everyone knows, is hard to prove because even if they had no legitimate business interest, who says they knew about you? Who says it was bad faith? In Microsoft.com, probably pretty clear to show there. You plan to trade off of Microsoft's name. In that case, Microsoft has the domain and the trademark. There's no legitimate interest for someone else to call themselves Microsoft. And number three, they could not have registered it without bad faith. Short of that, you're not getting a domain name from a client. Or from an adversary or whatever. All three of those prongs have to be met. And not only that, they outsource it to the American Arbitration Association, or WIPO, the World Intellectual Property Organization, and they hear it through arbitration. And it's very hard. It's just, let's leave it at that. I've had not such good luck with them. It's very hard to get a trademark. So what happened? Once they denied one of my clients, so then what does he have to do? He went to court. He has to go to court and fight it, and you can fight it in court basically based on trademark infringement. It's saying it's trademark infringement, therefore I need to get the domain for trademark infringement. But to do that, you do it not with the online, nice, easy file system for this trademark dispute. You actually have to go to a proper Article 3 court and adjudicate it for trademark infringement. All right. So next page, this is their specimen. 71 is the Law Review CLE website. They basically just, that's what they would submit as their specimen to show this is the downloadable audio. if they were to show a lecture, basically they would just show the advertisement for Michael Feigen, trademark attorney, patentlawandj.com, and they would show that on their website, and that would be acceptable to show me using it. Now, if they didn't have a website, they would show the flyer that they mailed to you in your mail or whatever, that type of thing, for a service. For a service, you could do that. All right, and now we get to T's Plus application on page 73. They're showing where you upload the specimen, you hit upload. Now this is something recent they added. You can upload actually a movie. It used to be I would have to take screenshots out of a movie if that's where they used it. YMG films, we need to take screenshots out of the films themselves. So now we just upload their intro to the movie, whatever, and whatever's there. Keep in mind anything you upload is public data. So you want to be careful what you upload. Attorney information on page 75. That's pretty self-explanatory. The second box is where you enter your docket number. Email address. If you're filing electronically, you must check the box authorized to communicate by email, and they will. $275 fee. You sign it electronically. The way you sign electronically is as shown on page, not numbered, on page, the one that looks like this, where it has a declaration. Declaration says, I'm not doing anything wrong, or you can put me in jail. And at the bottom, the way you sign it is you type in slash, you type in your name, or however you want to type in your signature. You can type in slash, I hate my trademark attorney, slash again. That would be called your signature. And that is an electronic signature with the U.S. Patent and Trademark Office. You put a slash before and after, whatever you type in as your signature, and they consider that signed. You click in the date sign box, it populates the box with the date automatically, and you hit submit, and it gets emailed around. You get this page, on page 79, you get this thing where you can download the data files and so forth. What I generally click on right away there is I download the data file, I click on text form, read through the text form is in plain English. Basically, their entire form, all it does is it, well, amongst other things, not only does it fill out all the data, it puts it in a nice, readable English trademark application as if you were to write the whole thing out and file it on paper. And so you can send that to a client to read and look at, and you have them sign electronically. Occasionally I have a client who can't figure out how to sign electronically, and you get someone to help them or get them to come to their office, they do it with you, that type of thing. There is a way to get them a pen and ink signature and then submit it. I know it's an option there. I've never done it, nor do I want to do it, but maybe other people would rather just have them printed out and do a pen and ink signature and submit it. And then you have a nice submitted trademark application. And then they're just showing you all the data, how it's populated in there, the following pages. And if you jump to page 85, this is what the full trademark application looks like. It has the mark. Little element is this, because this is standard characters, because this is a standard character mark. Applicant, it gives the name of the applicant, what kind of company they are, the address. It's got the filing basis, international class 9 for what are the goods, earliest date of use, at least as early as such and such a date. This is the type of stuff we used to have a template in a word processor and fill in for each client. Now it just they make it much easier for you. And then the specimen is on the next page. They show what it looks like on page 87, I should say. And then credit card payment. Credit card payments are great. You can have a deposit account with the U.S. Patent and Trademark Office with all your fees. They can do electronic debit. They can do debit cards. The reason I do credit card is for one and only one reason. My credit card gives me 2% back. I collect $275 fee as part of it for my client. I'm getting $5.40 back for every trademark application I file from that fee. So all my trademark and my patent fees I put on credit card and get 2% back, which is substantial because when you do patents and a patent filing fee, they want expedited exam, it's like $3,300 and you're getting 2% of the back. It's a pretty nice legal way to get 2% of the fee back. Otherwise, I wouldn't touch a credit card.
So you don't sign the application yourself?
You do. They didn't show where that is, or maybe they did. But what happens is the client signs. Typically, what happens is you get to that form where it's a text form, and then you enter your email address. It becomes emailed to you, and then with a link that you then send your client. So it'll say, to sign your application, click here. So I say, dear client, copy and paste that line and leave the rest of the technical data out. Copy and paste that line, click here to sign your application. Please sign by typing your name between 2 slashes. You can't say, please sign your name like this, quote / name / quote, because they will try and sign it with the quotation marks. I found that too many times. So you have to find a way to write it. Please sign your name between 2 slashes like this, colon, blank line, / Michael Feigen /, but don't put Michael Feigen, put your name. And that generally works. You're generally able to figure that out. It's more cumbersome, but you get a signed application that way. Then it comes, you get another email saying, okay, they signed it. You click on your link now. Your link takes you there, and you can review it one last time, see that they signed it, sign your name between the 2 slashes, submit, takes you to the credit card payment form, put in your credit card, it's all submitted. It's basically, you just got to try it once. You just go through it once, do a test application, go through everything, and just, when you get to the credit card, don't pay the credit card fee and let the application die. It becomes automatically abandoned. They delete it from the system after 2 weeks if you don't follow through with paying the fee. So you can go through USPTO.com, follow this to try and file one.
Do you recommend like when it says disclaimer, not putting anything in and let them tell you what you have to disclaim?
No, I mean, I guess I'd say this. When you first start out, I think I would let them tell you what you have to disclaim. But once you get to realize, I put an .inc at the end or a .com at the end, or I put, I don't know, something else that's obviously descriptive. Miss natural, and they're going to, natural I probably wouldn't. I'd let them decide on natural. But if it's something that I know is a disclaimer, I just put it in because I want the mark to go through as easy as possible so I can tell the client, look, I did a perfect job for you. It went right through. I can see saying not, let them decide it, and you're responsible to the office action. You're going to be able to do more billable hours for that. But if you know it is and you know there's no chance, I think the ethical and proper thing to do is just get it to go through properly and make the client happier. Any other questions on this? All right, what time we got? All right, 16, 17. All right, so once it's filed, this is what the application looks like on page 93 when you get a rejection. So this is examiner's amendment, priority action. So the reason why this went right to examiner's amendment is because they didn't get a rejection or they're not showing it to you. And what they're doing is probably the examiner called the attorney on the phone and said, no, I take that back. Substitute specimen required. I think they mismatched 2 different pages. They said examiner's amendment, but it's not an amendment, that's a rejection. Substitute specimen required. I think they're just smashing together different things. Substitute specimen required on page 94 means that the picture you submitted was no good. You said colon, there's no colon. Give me a new picture. Instead of giving you a new picture, you can amend the mark. Depending, because obviously the client is either using it one way or they're not. So you want it to match how they're actually using it. So, and you have to say that statement in bold. It was used in commerce. They started the 5 year the application. If you amend it to 1B, if you remove your filing date, 1B is intent to use, then you have to say, okay, fine, you got me. My specimen's no good. I'm making this a 1B, but I still intend to use it, and you can save your trademark application that way. That happens, for example, the client screws up. They go and submit their business card when it's not a service mark, but it's a trademark. They submit their business card when they're offering window blinds. That's no good because they protected window blinds, not the service of selling them. So therefore, they've got to remove it, and we either submit a new specimen that's proper and the statement that says I really was using it and I just screwed up, or okay, it's an intent to use. I really haven't sold any window blinds such as handing out business cards. And you have to submit it electronically once you start, or you pay the additional fee to make up for the discount you got for filing it using the T's Plus application. Examiner's amendment, down at the bottom, page 95. So sometimes this is by phone or email. The examiner, either you call the examiner or they call you, and you agree on an amendment and fix it up. For disclaimers, a lot of times they'll just call me up and say, your trademark's fine, but I need to enter a disclaimer for this word. Do you approve? Yeah, sure. Examiner's amendment, you get an email, it moves on. And you send it to the client, and so forth. And then this looks like another one of the specimens at 97. the response starting page 102 is what the response looks like when they submitted a proper specimen, and the text of the response is on page 105. And you can see how they changed it from audio and video recordings featuring legal education to audio recordings featuring legal education, because they're pretty, pedantic like that, where they are very specific how the goods and services need to be listed. Some of my business I get from international clients that they file trademarks. They come into the United States, and they said, trademark was absolutely fine in Europe, trademark was absolutely fine in Australia. I have an Australian attorney I work with, and we forward business back and forth to each other. He does all my Australian stuff, I do all his American stuff. Happens all the time with trademark applications. They're fine in Australia, come to the United States, they have a problem. Then we have to amend the goods and services to conform with how the United States wants it listed as opposed to how Australia wants it listed, because Australia is much more open with it. If anyone is ever going to Brisbane, Australia, I know a great attorney there. Never spoken on the phone either. We just email each other all the time. All right. I asked them about the cane toads over there. Tells me they are in fact a real problem. They introduced cane toads off a boat from England to try and kill the pests eating the crops over there. And the problem is in Queensland, which is northeast Australia. They've basically taken over, and these cane toads have no natural predators in Australia, and they basically eat everything else there, and it's a huge problem. All right, and then this is just, they've given all the information that's in the trademark file, and eventually on page 114, this is what an issued trademark certificate looks like. It's a little prettier for real because it's in full color, and the mark itself, it's in color, will be printed in color, and you get a nice cool seal with David Papos' printed signature on it. Registration number 4140479, registered May 8th, 2012, and all the information's there. This is where you would see like the disclaimer would be listed, and translation would be listed amongst that text. So it was registered May 8th, 2012. When do I need to file the first affidavit of continued use?
2017.
Yes, correct. Well, between the 5th and 6th year. So the window opens May 8th, 2017. It closes May 8th, 2018. When do I notify the client about this?
As soon as possible.
Tomorrow? Actually, yes. You know what? You're right. Because you have to notify them once it's issued, the next step. You're right. That was a trick question that I didn't even realize was a trick question. You notify them that they're going to have to pay maintenance fees or the trademark will become abandoned. If you don't and it goes abandoned, they can sue you. They won't, because you'll talk to them and you'll nice them and you'll tell them, it's okay, I'll just refile your mark with the initial date of use. And it's fine, I'll make it work and I won't charge you. Then you won't get sued or reported. But you don't want to have to do that, because who wants to do legal work for free? So what you do, you notify them then, and you maintain a calendar. My insurance, which is specialized for patent and trademark, they actually ask, do you maintain a calendar? Do you maintain it in two separate forms, one of which is not a printout of the other? That type of thing. That to maintain a calendar and make sure that you know when to notify them. And I notify them again. I try and notify them again before the window opens up, because I want to be the first one to notify them, because this is public data and there's automatic notification services, which is a double-edged sword. One, they can't say they didn't know because they got 4 people spamming them about it. But 2, it could take away business. But, it's competition. But you notify them then. I like to do it at the opening of the window, not the close, and just get it done and not wait until deadlines are there. And I saw someone look at their watch, and it is, I got 6 minutes, sir. Okay.
I just have to make a phone call afterwards.
Okay. So, sorry. All right, that concludes this booklet. We've got 6 minutes for any questions. Yes?
What's the period? Is there a certain period of time if a trademark owner is not using their trademark that you can file for cancellation?
Yes. There is a presumption of abandonment for failure to use for 3 years, I believe. It's a rebuttable presumption, but the presumption is against them if they can't show any use for 3 years. They would show things like, I continue to try and use it, I've been trying to arrange sales. I had a case with Levitt's Furniture, Levitt's Furniture was around for a very long time. I had a client who filed a trademark for Levitt's with an S, and it has actual stores in the Bronx, I believe. Levitt's with a Z was bought out by some IP holding company, and they did nothing with the mark. And they sent a cease and desist letter. I countered it's abandoned. I responded to the cease and desist letter. They went and sued in court. A colleague of mine actually referred them to started defending this in court. And we actually had really good arguments, basically saying that it's probably abandonment. They don't know when they abandoned. They didn't even know. I mean, we looked at the trademark filing because they filed excusable non-use document, which is obscure things. The only time I've actually seen it. They filed for excusable non-use. So we're not using it, but we want to maintain the trademark because we're trying to use it. So there's that. But they didn't know when they stopped using it, and it was over 3 years. So the attorney for the other side thought it was an open and shut case. We're going to sue these blankety blanks, and that's it. We're going to get them to go away because they're not cooperating. And the attorney that I was working with who handled this case in court said, he told me this and said he was like really surprised that we had all these good arguments come back and we just didn't even realize. And I think they eventually settled. Clients stopped paying their bill, so we stopped continuing with that one. But that's the nature of clients registering a trademark for Levitt's with an S. Anyway, all right. One last question. All right, so why don't we, do you have a question? Okay, because everyone else will be really mad that you're keeping a few more. So why don't we end it there? Again, patentlawNJ.com. You can look me up, find me, business cards there if you haven't placated my ego and picked up one yet. And feel free to email me and contact me with any trademark questions about life, the universe, and everything. I'm happy to talk to you. Thank you for coming, and if you should need my services, that also would be wonderful. That is all.